Thank you. Please be seated. Before we begin the calendar today, I'd just like to say it's truly an honor to be here at the Robert H. Jackson Center holding a term of this court for the first time outside of an official court building or a law school. As most of you know, Justice Jackson was a true American patriot, serving his country not only as an associate judge on the N.Y.S. Supreme Court, but as chief prosecutor at the International Military Tribunal at Nuremberg post-World War II, in which his commitment to fairness and the rule of law helped keep order at an otherwise very chaotic time. It's our, and I'll speak for all of my colleagues here on the bench, it's our pleasure and our honor to be holding a session of this court at a center dedicated to such a man, and we deeply appreciate the overwhelming hospitality and warmth shown to us by the directors and staff of the Robert H. Jackson Center. They have really outdone themselves. And now, to honor Justice Jackson's commitment to the rule of law, we will move on to our calendar of cases. The first case on for argument today, case number 1257, 1258, People versus Williams.
Good morning, Your Honors. I'm Charles J. Greenberg for Curtis Williams, who's currently serving a sentence for his conviction to criminal sale of a controlled substance of the 5th degree, as well as to a violation of probation. My client was found guilty of criminal sale of a controlled substance in the 5th degree after a jury trial in Seneca County, where the allegation was that he sold drugs to a fellow inmate at the Seneca County Jail. He was actually not an inmate at the time, but the allegation is that he was had somehow smuggled in the drugs at when he was, well, actually, more precisely, that he somehow...
He had an intermittent sentence.
He had an intermittent sentence. He was there one weekend. He went away during the week, and then he came back.
Counsel, the issue that you've raised, at least as I'm reading it, insufficient evidence and weight of the evidence, and you're talking about specifically the transfer of the drugs, right?
That is correct.
That's one of your issues raised?
That is probably the only real issue, is whether there was any real transfer of drugs.
Was that preserved? Was that issue preserved below? Was that specifically argued below?
Well, it was specifically argued in the sense that the trial lawyer did do a motion to, at the end of the people's proof, to dismiss it on the basis of insufficiency. So to that extent, you could reach the issue. On whether he referred to that very specific issue, I don't think he did not. I think he did. But nonetheless, because he did make a general motion at the close of the people's proof, you can certainly reach sufficiency as a general principle.
So because it wasn't hand-to-hand, just because he went and picked it up by the phone?
Well, how did he get it in, though? I mean, the issue, I think, Your Honor, that was a very good point, is how did he get the drugs into the facility, the police officers?
Well, he certainly seemed to be aware of how some people did it. He said, I'm not going to stick it somewhere or something else. He's certainly not unaware of how you bring drugs in.
The police or the corrections officers who testified we're not aware as to how he got it, and I'm sure that they're familiar with how to get drugs into a correctional facility or a county jail as well.
But certainly the fact finder could consider the circumstantial evidence that was presented leading up to what is claimed to have been the introduction of the drugs into the facility.
You certainly can take into consider that as well, but then when you look at the phone calls going between, I don't think between the gentleman who purchased the drugs and the people who's speaking to on the outside, I mean, well, take into account that they'll speak with codes and whatnot. I mean, is there any evidence?
They thought they were speaking in codes that no one would figure out, but perhaps they weren't as smart as they thought they were.
Well, but did any of this really implicate my client, though? I don't think he called my client. I think he may have called other people that my client may have known. And then also, how would my client, because he was wearing the ankle blanket not blanket, bracelet, when he was during the non-incarcerated portion of his intermittent sentence, how could he have gone to Rochester to purchase these drugs without somebody knowing that he had gone to Rochester?
Well, some would argue where there's a will, there's a way, and that it would not necessarily have been necessary for him to do the traveling. But in any event, when you look at some of the evidence and the complaint, there was a request for a specific type of drug, and the recipient was upset. There was evidence of that. Isn't that something that the fact finder could consider, taking all of that together as to
Yeah.
whether or not your client planned and/or carried out?
Well, that would be everything you said is correct, Your Honor, but all of that goes to the buyer's side of the transaction, not the seller's side. Does that necessarily prove that my client was the one that consummated the sale? So I understand.
And you're
that the-
saying there's proof, but
Yeah.
it's just not sufficient. That's your argument with
Well,
respect
there's
to the
proof that a
trans-
sale-
and the weight of the evidence.
Well, yes, there is proof that the sale occurred. The gentleman, the buyer certainly got some sort of pills. He was found.
Your client's not disputing that those conversations, those coded conversations were about drugs? That's all part of what's before us?
He's arguing basically both from a sufficient standpoint as well as a weight standpoint that he's not disputing that the conversations occurred. He's not that somehow.
Isn't that enough? I mean, isn't it enough that he just agreed to agreed to the sale?
Yeah, but did he consummate the sale? I mean, if he agreed if all he did was agree to the sale, then that may be sufficient for attempt. Like if two people agree to commit a crime, that's sufficient, of course, for a conspiracy. But I don't think that's necessarily sufficient to actually convict him of the actual sale, though. It may be a very fine distinction, but that's basically what his argument is.
Okay.
Any further concerning that? As far as the violation of probation, I will leave the court's discretion on that one, unless you had any questions on that.
Thank you, counsel.
You're welcome.
Good morning, Your Honors. May it please the court. Josh Sonner on behalf of the people. I think it's interesting that the preservation argument, or the preservation question, was the first one that came up, because I think in some cases, preservation gets looked at and passed right over. We go right on to the merits. With this one, I think it matters. What they've argued in brief is that the people had failed to demonstrate sufficient evidence of a bona fide offer to sell, not a completed sale, but a bona fide offer to sell, which was something that was never addressed in any of the motions to motion for a trial order of dismissal, either the original one or the renewed one after the defendant put on his case in chief. The first time it's raised is in a 330-30 motion to set aside the verdict. So the people are put in the position of having to argue sufficiency of the evidence under a theory that was never addressed at trial. Nevertheless, as I've argued in brief, I believe that if you're looking at either under the theory that there was a consummated sale or under the theory that there was an offer to sell, a bona fide offer to sell, that the evidence that the people presented at trial.
It seems that the defense is taking issue with the consummation of the sale.
I believe that as well, although, again, in brief, I think they argued about whether there was the bona fide offer because somehow the defendant couldn't do it because of the ankle bracelet
Right.
or a lack of funds. But I think if you, and Judge Troutman, you raised this, if you're looking at the evidence as a whole, you have a series of phone calls. You have a phone call between the defendant and Mr. Kazmarek where they're specifically talking about drugs. Both of them testified at trial that they were talking about drugs, and the defendant smuggling them in. They're talking about a specific price. That was $250 for the drugs that were delivered. Immediately after Mr. Williams comes in for his weekends, he's on the phone with his girlfriend saying, Mr. Kazmarek, Jake thanked you. He appreciates what you did for him. And they start talking about where the $250 check is going to go to once Mr. Kazmarek cashes out his commissary account. And then he sends a note that same weekend on to the jail staff asking them to withdraw $250. They intercept it when the drugs are caught. As far as the evidence of the consummated sale goes, you have a view of the evidence in the light most favorable to the people with regard to sufficiency. Mr. Kazmarek testifies that he leaves them on the phone, Mr. Williams leaves them on the phone, he picks them up right there. He's found with the same drugs in his cell in the same packaging that he testified that Mr. Williams delivered to him. I think that there's more than sufficient evidence for the people to support the conviction. I also think that the conviction's not against the weight of the evidence. I believe it was particularly the issues that were raised in brief regarding Mr. Kazmarek's reliability as a witness. Those issues were vetted by defense counsel during cross-examination. Everything that the jury should have considered is everything that the court should consider with regard to the weight was before the jury, and I think that their verdict was appropriate, should be upheld by this court, and I would rest the rest of my time.
Thank you, counsel.
Thank you, Your Honors.
Case 1259, People versus Claus. Proceed, counsel.
Good morning. Erin McCampbell on behalf of defendant appellant Taylor Klaus. May it please the court.
So let's get right to it. Really, the question, you know that I'm familiar with this case because I
Yes.
granted you a
Yes,
stay
Your
in
Honor.
January, stay of the sentence. So the question is whether the court knew it had discretion, that it was required to exercise it and did, right? I mean, that's really why we're here.
Correct. And I believe the record reflects that the judge stated that because he had stated in the past that he would have a 0% or 100% compliance policy, zero tolerance policy with violations of probation, that he had no other choice. Those were his words on the record.
Yeah, no other option.
No other option, excuse me, but to revoke probation. So based on what's in front of us on this record, not what may have been in his head, but what is on this record and in front of this court, he did not exercise his discretion at sentencing. He had options.
Well, he did pick a number, and that number wasn't the only number available to him about the length of the sentence he could have imposed.
But he didn't exercise discretion in the sense that he didn't choose between the three options he had available, which one of them was to continue probation as is, one of them was to modify the conditions of probation, and the third would be to revoke probation and to impose a sentence.
In order
But
for us.
there was discretion about the length of the sentence. You're not denying he didn't know that.
Well, I mean, clearly he understood he had options on the sentencing, but he indicated on the record that he felt locked or that he believed he was locked into revoking probation based on what he had said at the original sentencing. And those are the words on the record, and those are the words that this court must look at when evaluating this sentence.
So you're not arguing that if you look at the evidence, taking away the words that he said, that there couldn't arguably have been a case for a revocation of her probation?
Well, I'm asking, I believe that on the facts and circumstances before that court and now before this court on interest of justice jurisdiction, that the appropriate sentence would have been what probation and her counselor recommended, which was
I
a
understand,
modification.
but you're not arguing that she didn't technically violate probation?
No, I'm not arguing that. She
Thank you.
missed 4 meetings, and she accounted for that. She apologized to the court, she took control, and she pleaded guilty for those violations. So I can't argue that she didn't violate parole. The issue I have is that, first, the court essentially abdicated its discretion in making a determination among the 3 options it had available to it, which would have been either continuing, modifying, or revoking. And secondly, in light of the facts before that court and before this court on interest of justice jurisdiction, I believe that the appropriate sentence is what probation recommended, which was
Yeah, that's
a
your secondary
modification.
argument. That's your secondary
Yes, it
argument.
is.
Very good. Thank you, counsel.
Are there any further questions? Thank you.
Good morning, Your Honors. Laura Jordan on behalf of the Niagara County DA's office.
The trial court did make some pretty ill-advised statements. This statement that I have no option but to revoke your sentence of probation is troubling.
Right. But I think if you look at the sentencing transcript of a whole, the lengthy discussion about the different sentencing options brought up by both the prosecutor as well as the defendant, the fact that he used the phrasing that he has no other option, I don't think implies that he literally felt like he had no other option.
Are we not to take the judge at his word?
I think if you take that statement in the context of everything else that was discussed, there was never any implication that he felt like the only thing he could do was put her in jail for 1 to 3 years. He knew that there was other options there. When he pled initially,
The record seems to indicate that he's, actually, if you go through the totality, that he's actually considering, as he talks out loud, considering the implications of making those other decisions. And so it does appear from the reading that he is considering those other options, although I couldn't agree with Justice Peredato more. You know, the phrasing was ill-advised.
right, and I would be willing to concede that point, but when you look at it, again, in the context of everything else that was said, I don't think he felt like that was literally his only option. At the initial sentencing, he informed the defendant that her exposure was to 15 years. He never said to her, I have no other option, this is what I'm going to do. If you violate the terms of probation, she was advised that you're going to expose yourself to this, and so he certainly didn't sentence her to the maximum that he could have.
Okay.
Thank you.
Thank you, counsel. Case 1260, People versus Kutea.
Good morning, Joe Frazier from the Niagara County Public Defender's Office on behalf of Mr. Kutea. Relatively simple fact pattern underlying 2 discretionary decisions by the trial court. 2 unrelated sexual offenses, 2 separate victims, approximately 8 years apart. He was acquitted on one, convicted on the other. There was a application by the people to allow proof of prior bad acts to explain why the 8-year-old case was not reported to the police. Those bad acts, however, had nothing to do with the other victim.
Yeah, but
But
didn't
it-
oh, go ahead.
But in this instance, the case that evidence was used for, the defendant was acquitted.
But the outcome of the trial doesn't really matter. The same jury heard this proof. So the question of whether Mr. Kutea beating this kid rather violently was still heard by the jury in relation to the other case.
But didn't the court give a very specific instruction to the jury about how they were to view this evidence and use it?
He did, and courts always do that. And that's
Well, not always,
Well,
sadly.
So in many cases, I'd say that's the standard and not the exception. In this case was he gave instructions. The judge gave instructions.
And not only do we know he gave instructions, but we also, know that, we're to presume that the jury followed those instructions, understood them and followed them.
Absolutely, and again, but that's in every case. And the question, though, really is, did the court exercise its discretion? Did it look at those beatings of this young boy in relation to the fact that they had nothing to do with this other case at all? So when the court's weighing, the prejudice versus the probative value, on one case you've got the court saying, as to this boy, it's probative because we want to know an explanation for why did he not report this over 8 years. But as to the young female victim, there's zero probative value. It has absolutely nothing to do with it. So almost by definition, the prejudicial nature of those beatings
But again-
outweighs the probative value as to that case.
Again, doesn't the fact that the jury considered that evidence as to that young boy and acquitted on those charges, even though the evidence was directly related to him, showing that the jury had the ability to follow the judge's instructions and considering the evidence as it related to those specific charges?
So I think then we'd be looking into the minds of the jury as to what they thought of this young boy's testimony. Keep in mind that this happened when he was under 13. This was 8 years later. So he testifies to being beaten on a number of occasions, again, quite violently. And
And there was difficulty, I think, in the testimony with respect to targeting dates or times and locations. And so I think what you're saying is that the jury may very well have looked at the specifics, found them lacking, and acquitted them, but still have thought something happened which might have prejudiced your client.
Right, exactly. And the prejudice comes from the jury hearing all this bad stuff about a guy. You know, the prejudicial nature, regardless of its truly propensity evidence. In other words, these weren't sexual bad acts uncharged. These were violent bad acts. So here's a bad guy, and that's the impression the jury gets. This is a bad guy. He's been doing this for years. He beats people, and now we're going to evaluate the testimony of this young woman and decide whether she's telling the truth or not. But this really ties in, and I wanted to hit this one point. It ties in with the severance issue. That could have been avoided by just giving this guy 2 separate trials. They were joined under the section that allows similar charges to be joined. But there's a safety net.
Your two arguments really are connected. I mean, your main argument is that this proof infected both cases.
Correct.
So they should have been severed, and the proof shouldn't have been allowed.
Correct.
I think we have that.
Thank you very much.
Thank you, counsel.
Laura Jordan, again, on behalf of the Niagara County DA's office. I think to Your Honor's point, the best evidence we have here that they were able to effectively separate these two issues, these two defendants, was the fact that they convicted on the count involving the female and did not convict on the count involving the male. The court provided
But it doesn't necessarily follow, as I just pointed out to your opponent, that, you know, they very well, I mean, the testimony of the young man was not at all specific with respect to the date, the place, the time, couldn't pinpoint those things. And the jury may, because of the passage of time, was a problem. And so the jury may very well have concluded that there's just insufficient proof on those charges. But still, the testimony was prejudicial. You're not arguing that, right? You're just saying that it should be allowed because it wasn't outweighed, the benefits of it were not outweighed by prejudice.
Yes, Your Honor. And the court also gave that limiting instruction, which obviously the jury is presumed to follow, that this was only on the issue of delayed disclosure, which was only an issue in the male's case. As far as the female, I believe the last incident that occurred with her occurred on a Wednesday, and she told someone on a Friday. So there wasn't even an issue of delayed disclosure involving the female's case that testimony would have affected.
When the court was considering the severance application, all of this information was before the court. In other words, the court knew that this testimony was going to come in, knew that there was going to be this problem that was going to be encountered during trial. Would you agree with that?
Yes.
Okay. Thank you, counsel.
Thank you, Your Honor.
Case 1261, People versus Gonzalez. Proceed, counsel.
Good morning, and may it please the court.
Do you agree that the, excuse me, do you agree that the proof shows that your client was definitely at the scene?
Yes, but just mere presence is not alone for
Understood.
conviction.
Okay.
Mr. Ayala Gonzalez is spending the rest of his life in prison based on evidence that pointed away from him into the drug dealer next door. However, the jury was unable to see this because their view of the evidence was tainted, and even their view of defense counsel was tainted by pervasive prosecutorial misconduct. I'd like to focus today on points 1 and 2 of the brief and address any questions the court has on the remaining points, beginning first with the insufficiency and weight argument. There's no way around it, and the people can see that this is a circumstantial evidence case.
But that doesn't necessarily make it a weak case, does it? If there's a lot of circumstantial evidence, that's sufficient to convict.
There can be, but I don't think that was here in this case, respectfully, Your Honor. What we have that's most problematic is the issue of identity. We had so many different people who were at the scene, and not one of them got up at trial and said, that's the guy I saw running from the backyard. Everyone that was there gave differing descriptions of who they saw fleeing from the backyard.
But there was a distinctive description of a man with a blonde ponytail.
From some of them, yes, but not all of them. If perhaps...
Do all witnesses have to identify, to testify, to the exact same thing as viewing?
No, I don't think so, but
And isn't it true that people have different vantage points when they're witnessing something? It's up to the jury, though, to determine what they believe and what they found credible based upon that person's ability to make the claimed observations.
That's true, Your Honor, but there is case law out there where there's people where they give so many differing descriptions that can be a problem for weight and insufficiency, which I submit is what happened here. If perhaps everyone had given the same identification of who they saw fleeing from the backyard, the height was all the same, the clothing was all the same, the hair was all the same, everyone even gave differing descriptions of this allegedly unique haircut.
And are we to also, or was it appropriate for the jury to consider, they've been seen arguing before, to consider the other circumstantial evidence along with that ID?
They can, but the problem with that argument that allegedly happened, it was witnessed by another individual who I submit was more credible, and I don't think the jury considered that because of the bolstering later of that witness by the prosecution in summation. We had one witness who was actually the decedent's friend or girlfriend, who was actually mere feet away at the foot of the driveway when the shooting allegedly happened. She knew my client, she had seen him before and said it definitely wasn't him. And she's the one who was also present earlier at the same time that Juan Davila, who is the witness I believe you're speaking of, heard an argument allegedly. And she described that conversation as amicable. It wasn't an argument to her, and she was actually closer and had a better vantage point, which I think the jury should have considered.
Was the defendant identified by the driver of the yellow truck
Yes,
that
but
he got in? And he
that's,
said he had a gun when he got in the car.
yes, but problematic with that too.
Then there was another witness before that who said, I don't know if it was the defendant, I admit I didn't see everything, but I saw him get in the yellow truck and he was running from the scene and had the gun. So it seems those two circumstantially are pretty strong, placing him there with the gun in the yellow truck, who the driver admitted he knew him for a while.
Actually, the driver said he had limited interactions with him.
But he
The
did
driver
know who
would-
got in the car with him. It wasn't like he was sitting there and some stranger jumped in the front seat with a gun.
They were going to
He-
celebrate the birthday, sorry, Justice Nemour. Remember they were going to celebrate the driver's birthday that day? They knew him that well.
Right, right. But what the testimony that came out at trial was we had a few interactions. So we have this witness who allegedly sees a gun, who, by the way, what's problematic with that is he never identifies the gun at trial. He never gets up there and says, that's the gun I saw that day, even though the gun was moved into evidence. And Deborah Brooks, who I believe is the other witness you're referring to, she didn't get up on the stand on the day of trial and say, that's him. She just gave a description. So we have people who weren't present at the scene who gave in-court identifications, and we have that one driver who saw him get into the vehicle and couldn't even identify the gun. So I don't think there's enough evidence even on the gun aspect to connect that to him. There was no confession in this case. Perhaps if we had a different case where there was DNA on the gun, which he was excluded as a contributor, perhaps if we had the police who had investigated all these different leads that they had, like the drug dealer who was identified by people, and other people whose names were given as, possibly having a connection to this case.
Could you address the other point that you want to number 2, the prosecutorial misconduct?
Yes, I
Is
would
that
like
what
to address that, Your
And
Honor.
on that, you've got a lot of different issues that you've raised, correct?
Yes.
Would you mind, just for my benefit and for my thinking process, tell me what you think are the most important?
I
Start with the worst example and then go from there, please.
Well, first and foremost, I think in a case like this, where the evidence is weak, the prosecutor committed grave misconduct by misstating the evidence. And she did this primarily in summation, starting off early on by saying, 6 people saw my client running down the street, and most of them saw him with a gun, which just is completely different than what the evidence suggested at trial, because none of those people identified him nearby. Aside from, as Your Honor points out, the person.
To what extent is that preserved?
That one, there was an objection to that early on in summation, Your Honor.
Okay, thank you.
And eventually, defense counsel did move for a mistrial, moved for 2 mistrials in this case. And I think what's telling here is there were 4 objections that were lodged in summation, which is actually quite rare, unless the misconduct is that terrible. I think the other problem here is once she misstated the evidence, it was kind of a rolling effect and everything got compounded because she then started to denigrate defense counsel. There's really no excuse for some of the things she said about this attorney.
Well, what about the argument that it was fair comment? There was a complaint by the defense, there was shoddy police work, and that the comments of the prosecution were in response to defense counsel's own closing.
I don't think that denigrating defense counsel and accusing him of trickery can ever be fair comment. And I think the case law is pretty clear on that. And what he was commenting on, I think what she stated later on when he made the mistrial motion, is she thought that he was twisting the evidence around, and he explained he was making a sufficiency argument. Even if you comment on whether the police work is shoddy, I think that is something that should be addressed before the jury. And it doesn't mean that you get to attack defense counsel.
So your argument is it was so pervasive it denied your client a fair trial?
Yes, well, particularly when we have a case where the evidence is weak, and the jurors are looking at the attorneys as the litigators to tell them what the evidence is. And the prosecutor denigrates defense counsel to the lengths that she did.
But that was cured with an instruction from the court, don't you think?
I don't think the court's instruction was enough. I think at this point only a mistrial was appropriate, which defense counsel did move for. The jury instructions that were given were just the cursory ones that are typically given, nothing more, nothing less. But you can't accuse defense counsel of engaging in trickery, because once his reputation and once his credibility is decimated before the jury, they're only going to rely on the prosecutor for what they're hearing for their evidence or what arguments they should go with.
And part of your argument is this can't be harmless because this is a very close case in terms of the circumstantial evidence case.
Exactly, so Crimmins would apply. It's not just harmless error.
You should begin to wrap up, counsel.
Okay. Aside from that, there was vouching for her own witnesses, and, we had that Brady issue where the identification came up later, and she actually kind of skirted around that in summation. And my client didn't really receive the aid from the court. The misconduct was tacitly approved by the court in some instances, particularly where she was denigrating defense counsel. The court just told her to go right ahead, as if approving it. And in conclusion, though, my client didn't stand a chance of having a fair trial with the evidence as it was, and then with the prosecutor coming in and committing all this misconduct. He had no one to turn to for the vanguard of a fair trial. And this evidence certainly does not support a conviction for life in prison. And for that reasons, I would ask for reversal. Thank you.
Thank you, counsel.
May it please the court. Michael Hillary, appearing for the people.
Can we start with the second issue that your opposition addressed?
Yes, Your Honor.
Trickery. Is that appropriate, sir?
No, Judge, I don't think that was, I think that was better left unsaid. I won't argue that.
So how do you address that?
Well, Judge, I think that you have to look at what the prosecutor did as a whole. No trial is a perfect trial. I think if you look at the whole of the closing argument by the prosecutor, it was fair play. It was within the bounds of rhetorical advocacy. I think that if you take the arguments of counsel as to why misconduct was committed by the prosecutor, you see of some 20 or 30 arguments raised, 2, possibly 3 being colorable. I have argued in my brief that many of the alleged instances of misconduct by the prosecutor were in fact wild distortions of the record. For example, the defense attorney, the appellate counsel, argues that the prosecutor represented in her opening statement that the medical examiner would testify that the bullet removed from the victim's body was fired from the defendant's gun. That is not at all what the prosecutor said. The prosecutor said that you would hear testimony from the medical examiner about removing a bullet that killed Manuel Mateo, the victim. Now, that's just one example, and I don't want to belabor this, but a number of these examples that were raised by defense counsel, appellate counsel, were simply not misconduct at all because they were simply not correct reflections of what happened during the trial. Now, no, I will not argue that the term that Your Honor referred to, trickery, was appropriate, and perhaps the prosecutor would like to have had that word back. But in the heat of the exchange that occurred here, one in which the police investigation was very vigorously attacked, one in which the prosecutor was attacked in the sense of why children weren't called, it's understandable that the prosecutor would have perhaps reacted the way that she did in this case, in that instant. I'm not advocating for that, but I'm advocating that the court look at the record as a whole.
Do you think that defense counsel's acceptance or apparent acceptance of the curative instruction was a waiver?
I'm sorry, Judge, I didn't hear that last
Forgive me.
part.
Do you think that the curative instruction that the court offered and delivered ended up being a waiver by defense counsel when they accepted that on the mistrial motion, or no?
I think that that was adequate in a case like this to assuage concerns that that singular comment by the prosecutor would have swayed the jury, would have made a difference. And I also predicate that argument on the assumption, based on review of the record here and familiarity with the proof, that this was a much, much stronger case than is presented in the arguments of appellate counsel.
But getting back to the first point, you would say this is definitely a circumstantial evidence case, correct?
Yes, Your Honor.
But you would think that the pieces of the puzzle all came together based on the identification, because it's the identity that's really the issue here, right?
It is, Your Honor.
Okay.
It was a revelation for me in all candor. When I first reviewed this case, I thought to myself, this is a difficult case. Doesn't seem to be a lot here. And by the end of the process of responding and crafting this brief, I was very persuaded with the proof. I know that's a personal note, but in the case of circumstantial evidence, it is, as the prosecutor said, a building process. And when you put all of the pieces together, which were painstakingly marshaled by the prosecutor, they all amounted to a very compelling case that defendant was the killer. We have the testimony of Felix Villan, as Your Honor already indicated, who had driven that yellow Ford with the defendant, was familiar with the defendant, had spent hours with the defendant celebrating his birthday, driving the defendant to the scene and having defendant return to his vehicle with gun in hand, unwilling to give an explanation as to why he had the gun in hand. We have Deborah Brooks, who has no other connection to this case except that she was in the vicinity on Herkimer Street waiting to engage in a drug sale, testifying that she saw that very yellow truck, that she saw an individual waving to that yellow truck, which was inching away as if to stop
What
it.
about the complaint that the young woman who was with the victim said it was not the defendant?
Well, Judge, we have, to be sure, identifications of other individuals. I believe that we're referring here to Christina Acosta, though I may be confusing.
The one who drove him from New York City?
Natalie Perez. I'm sorry, yes. Natalie Perez is interesting because if you look at her testimony in the timeline of events, and you consider the testimony of Juan Davila, who claimed to have seen the defendant outside 347 Herkimer Street an hour before, indicating he was waiting for a friend, and then hearing those gunshots and claiming that he, again, Juan Davila, left the house to see what was going on. He was a stocky individual. He was a heavier set individual, and it makes sense that Natalie Perez, who perhaps was not looking for anything in particular, had no inclination that anything of this sort would be going on, was surprised and happened to look up as Davila had come out. There's an explanation, in other words, for her pointing to another individual that's not the defendant, or saying that the person she saw was definitely not the defendant. She saw two individuals. The person in the background, who she also claimed to see, she could not see clearly because she didn't have her glasses on, I believe was her testimony. So there is a rational explanation that would explain very well, very neatly with all of the other proof, why she claimed that the individual she did see was definitely not the defendant. And I suggest that that proof is not compelling proof in this case. The defendant did not do it. We have a lot of harmony among the witness descriptions that match descriptions of the defendant by people who know him. The blonde ponytail, tall, thin, light skin. These come up over and over again. Of course, variably describe the hair as short, a mullet, a piece hanging down in the back. Yes, we have all of that. But they're all essentially, as we look at the proof, describing what amounts to be, or seems to be, the same individual. Yes, sir.
No questions. Thank you, counsel.
Thank you.
Case 1262, People versus Fitch.
Good morning, Your Honors. Paul Dell for Mr. Fitch. May it please the court. The Niagara County Drug Task Force.
Excuse me, counsel, is this co-counsel here?
This is Mr. Fitch, Your Honor.
Mr. Fitch, I'm going to ask you to sit back in the back, just away from counsel table, please.
Apologize, Your Honor.
No, that's quite all right. We can proceed.
The Niagara County Drug Task Force had been investigating my client for years. In November of 2015, a Niagara County Drug Task Force officer went to Mr. Fitch's residence with an arrest warrant. While there in executing the arrest, he claimed to smell marijuana. He then went and obtained a search warrant, and that resulted in this case. The important point in this case is that that arrest warrant was no good. As I was driving down here this morning, I was thinking about traffic stops, and I was thinking about this case. We all know that pretextual traffic stops are legal. A police officer that wants to investigate someone in a car can stop that car for a valid vehicle and traffic reason and engage that person in conversation. I submit that that essentially is what happened here. But if you go to the vehicle and traffic stop situation, you have angle, and that vehicle and traffic violation has to be valid. In this case, the reason they went to the house was not valid. That arrest warrant never should have been issued. There was no probable cause. It involved a weapon that was first taken from Mr. Fitch in 2010 and held by the Niagara County Sheriff for 2 years and returned to him based on an order from County Court Judge Matthew Murphy.
But wasn't there an
Yes.
assessment after the federal prosecutors declined to prosecute that there was a state case that was viable?
Well, that is exactly what happened. Mr. Fitch, for 2.5 years, went back and forth between the county sheriff and the U.S. Attorney's Office trying to get the gun back. Finally, the U.S. Attorney's Office gave him a letter and said, "We have no interest in it. Go to the Niagara County Sheriff's Office." And he went and he did that a couple days later. They already had an arrest warrant for him. They didn't arrest him. Instead, the next day they didn't call him and say, "Come to us and talk about the gun." Instead, they sent a drug task force officer to his home.
Is there some requirement in the criminal procedure law as to how they are to then decide or execute a warrant?
Well, the point, Your Honor, is that the gun was always legal, and it has always been legal under New York state law. And
Does a mistake by the prosecutor invalidate everything else? Is that your argument?
In this case, it certainly does, Your Honor. When 3 years previously, the same district attorney's office, the same prosecution office allowed that gun to be returned. And when the gun was seized by the county sheriff in 2012, it still had the exhibit sticker on it from the first time it was taken. And the decision by the DA's office to issue an arrest warrant was made after reviewing.
But wasn't there some confusion because there was a change in the law?
There shouldn't have been any confusion, Your Honor. The SAFE Act doesn't apply to this case at all. It went into effect while the gun was in the Niagara County Sheriff's office. If it was still in Mr. Fitch's possession, he simply would have had to register it. He couldn't do that because it hadn't been in his possession for over a year. There should be no confusion. And in the record, I included 2 letters that I sent to the district attorney and to Judge Clark with plenty of attachments, including the firearms trace, explaining exactly why that gun was always legal.
Would you address the conditions of probation?
The conditions of probation, I believe, were especially onerous. Mr. Fitch had negligible criminal history, if any criminal history at all. I don't recall, he might have had a violation. He pled guilty on this case, reserving his right to appeal to the nonviolent D felony for marijuana. And the conditions of probation put a GPS ankle monitor on him and basically put him on house arrest.
And did the court set forth any reasons as to why it was necessary for him to have a tracking device on him?
No, Your Honor.
And there were other requirements with respect to testing for controlled substances and an issue of your client being a medical marijuana user?
That's correct, Your Honor. There was never any allegation that my client had any substance abuse issues whatsoever. It was an admitted user of marijuana, and he had a marijuana medical card with him when he went to the probation interview. And I went to that probation interview with him. The probation department and the district attorney's office at sentencing took the position that he should not be permitted to use marijuana despite the medical authorization. To Judge Clark's...
Just so I grasp the
Yes.
other part of your
Sure.
argument, though, you're saying the arrest warrant was bad, therefore everything flows thereafter. You're not separately saying that the search warrant wasn't properly issued, or the finding of the marijuana plants in the basement, the finding of 20 bags or so on the counter, or the officer's testimony that they smelled marijuana. You're not addressing any of those. You accept that?
I don't accept it, Your Honor. I just don't believe that the court even has to get that far.
Very good. You should be wrapping up, counsel.
I'm done.
Very good. Thank you, counsel.
Laura Duran on behalf of the Niagara County DA's office again. So defendant has always maintained throughout the pendency of this trial that this arrest warrant was used as a ruse to be able to get into the defendant's house or get close enough to the defendant's house to be able to smell the scent of marijuana. This is simply not the case. Initially, I think the trial court was concerned that that may have been the issue here. That's why when they granted the Franks hearing, they laid out a number of questions that they wanted us to answer during that hearing. And some of those being, the delay and all that was explained. We were waiting for the feds to make a decision about whether or not they were going to prosecute the case. And I think one of the most telling things is...
Was the hearing, and forgive me, my recollection of the record, was the hearing relative to the search warrant, or was it the arrest warrant, or both?
Both, Your Honor. It was a Franks hearing, but it sort of encompassed a number of other issues with those questions that the trial court had for us. One of the most telling things is the fact that Captain Lombardo testified that his intention was to execute that arrest warrant while the defendant was driving. It wasn't the original intention to send him to the house, to send an officer familiar with narcotics to the house. It was to get him while he was driving, and when that didn't work out, he finally said, okay, go execute this arrest warrant at his house. Our position has always been as well that that gun has always been illegal. It was illegal before the SAFE Act. It's illegal after the SAFE Act. The only exception that he could lawfully possess it in the law is that he would have had to, or someone would have had to lawfully possess it prior to September of 1994. To our knowledge, there's never been any proof given to the court that anyone possessed it lawfully before then, and I believe Mr. Fitch was purchased it back in 2002, so we don't have that proof. Regardless of that, whether, we never even got to that point because that case was dismissed because he pled on this one. The information that the officers had at the time, that the DA's office had at the time, was that that gun was illegal. They ran it through the Niagara County lab. It came back as having characteristics that were not legal for Mr. Fitch to possess, and that was what that initial arrest warrant was based on, the initial reason why they were at his house, and then got the search warrant from there.
With respect to the conditions of probation and the requirement that the defendant pay the fees and be subject to electronic monitoring, did the court set forth reasons as to why that condition was necessary?
The court did not. I think that that was more so a condition that probation had laid out as something that they wanted as part of his monitoring. There wasn't any objection by the defendant at that point. There wasn't any move to withdraw his guilty plea. So I would submit, first of all, that that issue is not preserved. And second of all, the problem is we have an individual here who was possessing large quantities of marijuana. I'd submit much larger than would be used for personal use. But you also have an individual who's permitted to test positive the entire time he's on probation for marijuana because of his medical marijuana card. Now, does that mean he can smoke marijuana? No, it means he can use medical marijuana. But there's no way to monitor his activities, whether he's going to a stash house or someplace else and then testing positive.
And does the record support that the court considered those factors when fashioning the conditions of probation here?
I don't believe that the court went into that much detail, but I think that if you look at the record as a whole as to what he pled to, the amounts that he was associated, or he pled guilty to possessing, I think when you look at that as a whole, that condition makes sense in this case.
And you're saying there was a Franks hearing conducted?
Yes.
Got it, thank you.
Thank you, counsel.
Thank you, Your Honor.
Case 1263, People versus Arroyo.
Good morning. May it please the court. Lyle Hoydu for defendant Arroyo. He's challenging the trial court's decision regarding suppression of evidence. It was from a combined map and Engle hearing. And I would note that this appellate division has requested the people's exhibits from that hearing, and we've learned now that they're not available. And as defense counsel,
Well, if we're talking about the exhibits with respect to the dash cam,
exactly,
yeah, in the radio dispatch,
exactly.
yeah, we have those. And we've had the opportunity to look, or
Oh,
listen
you
to them
have
and
had
watch them, yep.
Okay, thank you. Then I'm going to focus on the consent argument, Your Honor. 2 points here. One is that the defendant did not consent to the search of the vehicle. And two is even if the court...
He uses the phrase in response to the question of consent to the search, at least as I picked up and listening to it, words to the extent that it's not a problem in response to the consent, and also I'm good. And the officer, why is the officer not fairly interpreting that to provide consent?
Well, because...
Admittedly, there was country western music being played over the radio, which I cannot for the life of me understand why that was happening, and it made it difficult to hear, but with some concentration, you certainly heard the defendant say those words.
Well, here's the issue, Judge, and it's from the Court of Appeals, People versus Whitehurst. They made it very clear that the people have a heavy burden through clear and positive evidence that there's a consent to allow a warrantless search. So the bar is very high to make sure that it's clear and positive. It can't be ambiguous. The office...
Feel I'm good?
Pardon?
I don't have a problem, I'm good, isn't clear?
That's the quotation, I believe, was, I'm good, when he was asked, which I have no idea what that means when someone asks to search.
Well, the language I heard was, it's not a problem, I'm good. And would it be fair for us also to consider as part of the consent deliberation here that once the officer then proceeded to go look in the car, in the trunk, the defendant wasn't objecting and saying, I said no, don't do that. I didn't give you consent. There was no reaction at all to that. It was...
Let's be clear, though, Your Honor. You're saying there was no reaction from the defendant at that point. Prior to that, on a routine traffic stop, the police officer draws his weapon on the defendant. He calls for backup. Additional officers arrive. Now a second police officer draws his weapon. They remove the defendant from the vehicle. They pat him down. They search him. They find no weapons. They detain him inside the rear seat of a police cruiser. They start interjecting a conversation about a robbery. They ask him if he
Now,
has...
we're familiar, we understand the facts, and I'll grant you this, but I'll grant you this, counsel. And the officer, I think, was asked at one point about this, and he said, yeah, it's not normal to draw your weapon for a routine traffic stop, a running of a red light. You know, the officer wouldn't normally pull his weapon, but the radio dispatch indicated 20 minutes before there'd been a robbery. was that an unreasonable approach to draw the weapon and shield it behind him as he approached the vehicle?
Regardless of whether it was normal procedure for the police, those circumstances created a situation of duress for the motorist.
You're saying that that's why the defendant wasn't going to do anything to stop them from doing, continuing their search?
He is capitulating to police authority, which is exactly what we want our citizens to do. I couldn't imagine being so bold under those circumstances that after the officer leaves, that you're then going to, he's locked in the back seat. So my argument is that even if those words could be construed as consent, they were given under duress because of he's capitulating to police authority. But I would challenge whether or not that rises to the level that the people require. I would just note for the court is that on direct examination, the sworn testimony of the officer, when he asked for consent, was, quote, this is coming from the defendant, quote, "Yes, you can, I'm clean," end quote. That's what the officer testified that he heard. So then it's only when he was confronted with the videotape where the words are, "I'm good, it's not a problem," come out, which I would argue on its face is ambiguous as to what that means. So I have no idea if the officer's actual recollection, if you take the officer at his word, he heard the words, "Yes, you can, I'm clean." Those were not the words that were uttered.
Mr. Ida, excuse me.
Yes.
You're talking a lot about the consent issue. What I
Yes.
want to do is back up just for a second. Tell me where the first matter of law violation happened. Is it the stop? Is it the invasive questioning? Or do we get all the way to consent? I mean, at what level do we have to seize the moment, so to speak, on your argument and say, here's the violation as a matter of law,
Well,
as opposed to credibility determinations? Thank you.
it's just as you've outlined, it's stepping stones, Your Honor. It's first that there's a three-prong approach that I outlined in my brief, but effectively, under Engel, you have to have a basis for the stop.
But that's a credibility determination, right? Sorry.
That is
Okay.
credibility.
So it's not a matter of law, so to speak. When does it become a clear matter of law that favors you in the step analysis without a credibility determination?
When you get to what the officer observed at the scene, that he considered the basis to then raise his questioning to the point where he's asking whether or not there's weapons. That's a Garcia case.
Right, you're at the invasive question.
Absolutely.
Got it. Thank
And
you.
I just would, if I could highlight for the court that the first report is two males, black hoodies, bandanas, black pants, no description of age, skin color, ethnicity, no description of a vehicle. The only thing that was a match for that vehicle is that they had two men inside, and then after it was pulled over, you could see that their pants were dark. It wasn't, the second report didn't come out until later, after it had already escalated to the point where he's talking about a robbery, asking about guns and weapons. So at that point, I believe the appellate division can jump into the analysis. Last point, Your Honor. The people argued somehow that the defendant abandoned the issue of consent. And I just want to be very clear. The defendant filed an omnibus motion. He argues the evidence was seized without consent. That's at page 405 of the record. At the hearing, defense counsel specifically plays the audio that you listened to that refuted the officer's testimony about consent. And then the defense counsel submits papers. This is at page 445 of the record, arguing, quote, "The people have not met their burden to prove that the consent provided for the warrantless search of the defendant's vehicle was properly obtained," end quote. So there's no abandonment of that issue. And under the case of People v. Whitehurst, it's a heavy burden on the people. They're the ones required to show positive proof. We don't have to prove anything.
Thank you, counsel.
Morning, Your Honors. David Harity for the People. Just a quick note about the exhibits. Just so the court knows, I had advised Mr. Hoydu last week that the exhibits were not available. They turned up subsequently, and now the court has them, but the confusion is my fault, not his. I just wanted to clear that up. With respect,
Your opponent says the consent issue is not abandoned for purposes of this appeal.
It is, though, Your Honor. The court's decision and the submissions were focused on the two issues, whether or not the stop of the vehicle was supported by probable cause, and whether or not the police had founded suspicion to ask for consent to search the vehicle. Mr. Hoyt is correct that the defense did include that in his omnibus motion. I acknowledge that in my brief, but it was not addressed in the court's written decision. The passage he cited I read to be as part of the issue of whether or not the police properly asked for consent. If the court disagrees with me on that, I welcome you to reread the decision. But I think that both the voluntariness and of the consent and whether it's unequivocal was abandoned by the defense counsel's failure to follow up on that and the court's failure to address that in the motion.
Isn't the critical issue here, at least perhaps in my view, the invasive questioning, whether the officer had enough evidence or enough suspicion to ask the invasive question? Because it's clearly invasive, correct?
Yes, Justice Curran, I agree with you.
That's the issue. Tell me about that.
I think that's the issue. So the police have to have level 2 founded suspicion to ask for consent to search the vehicle, and they had that based on a number of factors. The defendant's vehicle was spotted in close proximity to the crime, both in time and in place. The description wasn't perfect, but they partially matched the description of the robbery suspects, and the answers given by the defendants were suspicious. Specifically, they gave a stated destination, but according to the officer, they were not driving in that direction, and the defendant was unable to say where he was coming from. That wouldn't have rise to the level of reasonable suspicion or probable cause.
They had no coats or jackets on, and it was a very cold evening in Tabitha, I think the officer testified to, and that was suspicious because it might indicate that they were taking off their clothes to hide their identity.
Exactly, Justice Whalen. That's another factor. So the police did properly ask for consent to search, and the evidence was obtained pursuant to lawful police conduct. Thank you, Your Honor.
Thank you, counsel.
Skipping Dept.
Yes.
Thank you.
Case 1265, People versus Withrow. Justice Niemoyer is recused on this case. Proceed, counsel.
May it please the court, Nick DeFonso appearing on behalf of the appellant Calvin Withrow. I'd like to focus my arguments on the ineffectiveness arguments in points 1 and 3 of the brief and submit on the remainder. With respect to point 1, trial counsel made numerous errors that cumulatively deprived appellant Mr. Withrow of his meaningful representation.
Didn't ultimately the cross-examination elicit what counsel was really trying to show? I mean, yeah, there's no question there was some inexperience there, right? I think we would all agree to that. That is trying to mark an exhibit into evidence on cross-examination like that, that was probably not right. But I'm having trouble with your argument as to how the substance didn't ultimately come out in her cross-examination. You know, the main argument was the DA put the witness up to this on the robbery charge, right? And
Yes.
didn't she ultimately get that out in terms of the counsel?
Well, there were certainly some successes ultimately with cross-examination, but there is prejudice in appearing to look like you don't know what you're doing in front of the jury. That's one. And the second,
There's been a lot of lawyers that made money doing that.
as you say, Your Honor, but the second aspect here, with respect to the document part of the ineffectiveness here, is the failure to fully cross-examine Ms. Williams with respect to the note, because there was a part of the note that was more consistent with Ms. Williams' statement, which formed the basis for the argument against the element of asportation of the robbery. And so the failure there was because, it's apparent from the record that it was because she thought that she could call Ms. Rita to the stand, and that was ultimately rejected, and then the note was admitted as a court exhibit.
Counsel, I'm going to ask you to keep your voice up a little bit, or maybe move the microphone. I'm having trouble hearing you, I'm sorry.
Apologies, Your Honor. Another aspect of, another element here of counsel's ineffectiveness at trial would be the fact that she elicited testimony from the DNA expert that there was a hit in, or at least results from the CODIS
There was an
database.
interruption of that testimony, though, correct?
Yes, there was.
And
There was an interruption, but in the context here, the DNA expert had already referred to it as being a data bank, a DNA data bank. She referred to local CODIS at least. And I think it's obvious here that meant that Mr. Withrow had a criminal record.
You think it's common knowledge for the populace in general that the data bank reference would be to the fact that he had a prior conviction?
Yes, certainly it's not common knowledge what exactly CODIS stands for, or that maybe even CODIS is the data bank. But when we're talking, we've already mentioned that it is one. It is common knowledge that a hit here in a DNA data bank indicates a prior conviction. I think we have a colloquial term, the CSI effect. We know what DNA hits mean. And that was prejudicial, especially because it exacerbates the earlier revelation by the people's witness that he had a meeting with the probation officer. There was a curative instruction for that, but not for this DNA comment. And finally, the record also shows that counsel was not aware that the people could successfully request the lesser included charge of attempted robbery in the second degree. And this seems particularly significant in light of the fact that the entire defense, as you say, Justice Kern, was that they could not establish the asportation element of the robbery. And so essentially here,
You're saying that they couldn't establish that he had possession?
that he took the purse
That he took
and
the
put
purse?
it behind him in the garden. Right. That was the main
But
thrust.
there was proof that he took the purse. I mean, yeah, the proof then was that he put it down because he wanted to continue a physical attack on the victim. But how does that not constitute a taking of the purse or taking of the property?
Well, the attack was on the credibility of Ms. Williams, who was the person who testified that he took the purse and put it behind her. And that was impeachable by her police statement, which said that it just became loose and he ignored it. So that was the defense theory there. There wasn't other evidence, direct evidence that he took the purse, as opposed to having earlier attempted to take it on the porch or at a subsequent time. And so that was the main argument here. And so it seems significant that she was not aware that attempt could be charged, and so essentially conceded elements of a fact or elements of a crime that she didn't know
But
could be
it's an all or
put to the
nothing
jury.
case, right?
What was that?
It's really an all or nothing case. If the jury buys the argument that you should disbelieve the witness who was following the advice of the DA, because that was the argument in closing, right?
Yes.
In closing, the argument is the DA fed the robbery portion to the witness, believe her first statement that she gave the officer, not her later statement, and as a result, make sure that you don't believe her, and therefore you know that when she said that he ignored the purse, that would be the issue. All that came out, right?
Yes, Your Honor, yes.
It was all argued to the jury.
It was, but I think just with respect to this issue, which is whether or not there was any prejudice here by her awareness or unawareness of this possibility, I think that it's just speculative, because we really don't know what she would have done differently.
I'm sorry to interrupt you again, but on the robbery charge, it's an all or nothing case, whether there's a lesser included or not.
Well, I mean, I think I understand Your Honor's question. So Are you saying that even if she
Even
knew?
if it's a lesser included, there still has to be the taking away element, so to speak. The I'm not going to pronounce the word right, but the robbery still has to occur, right?
No, not really. If there's just
Where am I
attempted
wrong?
robbery,
Not if-
right?
not
You're saying if there's an attempt?
Yeah.
An attempt, he wouldn't have gotten the purse away from the person.
Right, so if he didn't ever actually
Forgive
end
me,
up.
I led you down the wrong path.
Yeah, if he never took the purse, then they could still prove attempt here, and.
You should begin to wrap up, counsel.
All right. Essentially, also, I just wanted to note that the prejudice here, I think, from the charge is also irrelevant, because I think this highlights the difference between the federal and state standard here, because what we're talking about is meaningful representation, right? And I just don't think that, when your attorney is missing material legal information about your case, that can really be meaningful representation. There are other cases, you can't, there are certain thresholds of minimum effectiveness, right? You have to know who your client is. You can't have had their case for only 5 minutes. You need to know basically what they're charged with, and I think closely related to that is this case where you need to know what they could be charged with eventually, and you can't just do an effective job by accident. There's this intentionality here that is important. So, I know Your Honor advised me to wrap up, but I just want to note with respect to point 3, I know it's an unusual argument. The argument there is that sentencing counsel, which is a different attorney, was ineffective for failing to raise to the court's attention at sentencing the existence of 2 serious psychiatric disorders that made their way into the record for the first time in the pre-sentence report, and were not mentioned otherwise by the court. And I think that
Was the court unaware of them at the time of sentencing?
The court did not. Well,
You don't know because you say the court didn't comment.
The court didn't comment, but she did make
But you
comments
said
that
they were
indicated.
in the pre-sentence
They were in the
report?
PSR.
They were in the pre-sentence report, and also the pre-sentence report noted that they were serious. They as much as they resulted in hospitalization.
However, the court gets the pre-sentence report in the privacy of the court's chambers, reviews same. Are you suggesting that the court is required to put on the record the totality of that which is contained in that report, as simply saying, I've reviewed the pre-sentence report?
Of course not. But I think that where you have, for the first time, mentioned that serious psychiatric disorders exist here, that there is some obligation to address it, or at least ask counsel.
But it was addressed a little bit. I mean, the defendant at sentencing said he was in fine health, and these were diagnoses that were made several years before the date of sentencing. You're not saying that there was anything in the PSR that indicated that the defendant was recently struggling with these mental health diagnoses, are you?
Yes, I am. The pre-sentence report indicated that he was prescribed medication at the time for those disorders at the time that the crime occurred. So it did indicate that these were things that he was currently dealing with, and were not just remote in time to the initial hospitalization.
They were continuing issues.
Yes, and I think that though the court in every case doesn't need to list out all of the factors that it considers, but these are, I would think, serious things, and then especially given the court's comments here that he was a thug with no conscience and that he had no excuse. I think that it's not immediately apparent that you can be a thug with no conscience and also be suffering from schizophrenic and bipolar disorder. I think whichever way you come down on that question, you're going to have some explaining to do, and there's going to be considerable qualifications there. And I think that for that reason, failing to at least say, Judge, this exists here, really did have a prejudicial impact on his sentencing.
Time, counsel.
Thank you.
Daniel Punch for the people. To address the ineffective assistance of counsel at trial. First, the meaningful representation standard, there does have to be an aspect of prejudice to that. He's denied effective representation when he is denied a fair trial by less than meaningful representation. Isolated mistakes or inexperience
fumbling through the first time she tried to cross-examine the witness, that doesn't equate to a lack of ineffective assistance of counsel. Regarding the notes of the ADA, the statement was that the bag was loose from her body when defendant grabbed her pants. That's consistent with the trial testimony. Those notes had nothing to do with the robbery. They were whether or not there was enough to charge a sex crime. So it makes sense that it wouldn't have details about the robbery. Regarding the lesser include, also I'd like to say on that, the fact that she asked to cross-examine the ADA later, that's a stretch to assume from that she did not fully cross-examine the witness at the time when she cross-examined the witness, because she thought maybe in the future she was going to be able to cross-examine someone else. Regarding the lesser included, the charge conference, it's not lack of meaningful representation to oppose an appropriate lesser included or to ask for a lesser included that's not going to be granted. There's just simply no harm done based on that, and the strategy was to disprove the robbery, which she did, regardless of whether it's an attempt or a fully completed crime. And finally, the ineffective assistance at sentencing argument is just based on assumption after assumption. I mean, a diagnosis 7 years prior of bipolar disorder, I believe it was, does not mean that it had any effect on him at the time of sentencing.
Would you agree with counsel's statement that the record reveals that he was currently on medication for that condition at the time of sentencing?
I would agree with what counsel said. I mean, it said he was prescribed it. I have no way of knowing. I don't think anybody does whether or not he was taking it, but he was prescribed medication. It had nothing to do with the degree of mental infirmity that he had. It just simply said there was a diagnosis 7 years ago. If defense counsel at sentencing felt that he wasn't suffering any of those symptoms, he had an ethical duty not to raise it at sentencing, I believe. So it's just an assumption based on assumption. And also, it was in the pre-sentence report, so it was in front of the court.
Thank you, counsel.
Thank you.
Case 1266 in the matter of Chrissy W.
Your Honor, if I may, Richard Sullivan, I represent the subject child. I believe that the parties are submitting on this case.
Very good. Counsel, thank you. Case 1267 in the matter of Faith B.
May it please the court, William Broderick for...
Why don't we wait just for a minute until everybody gets situated? Counsel, thank you. That's great. Please proceed.
I was actually prepared to submit and comfortable with my brief, but I do, on behalf of trial counsel, want to make a brief comment on the last point with regard to the missing exhibit. For her, that was a very important issue. It's the reason I actually got this appeal to prosecute. I had consulted with her on the way to achieve this to make sure that it could be preserved for appeal, and she followed that, and it was supposed to be kept and maintained by the courts so that this court would have a record of what was in there and the relevancy of what was in there to make a determination. Through no fault of my client, that record doesn't exist anymore, and it's part and parcel of the Erie County Family Court Clerk's attempt to try and make more space or save space. which I will tell the court is going to create these types of problems in the future, because that whole policy was developed not with an eye towards appellate rights, but with an eye towards saving space. And there are a lot of defects in there that I see
And
looking at
with
the
respect
policy.
to the record that we do have before us, how
Well-
does what's missing impact?
Well, I was not privy to that. I did not see that. I can only go from trial counsel's insistence that that was an important piece, and it was an important piece for her in her case. And it's not available because I wasn't able to get
But
it.
if you
I'm not
look
able
at
to
the
see it.
record that we do have and what the findings of the court was, what I'm asking, are you suggesting that there isn't enough, period? Or that what is missing prevents us to review the case at all?
I think that what is missing is important aspect of the case. It was important to her, and she thought that it would have heavily weigh on the case, which is why she offered it and wanted it considered. My basic recollection from her is that it had a lot to do with things that would impact the credibility of the statements that were made by the child, and that's
It
why
was
there.
admitted
So-
in the record that the child had a history of, quite frankly, telling lies, and that was before the court, wasn't it?
It was, not in a lot of concrete ways, which it might have been from this record. So I mean, I think that context is important in terms of that decision, and I think it goes
We'll
to the
certainly look at
overall.
the weight of that argument in the totality of this case. Your argument is, frankly, that the record itself was important below. It's not before us now. It's going to impact our ability to review this case in a fair way for your client.
Absolutely.
I think we understand that argument.
Thank you.
Thank you.
May it please the court, Richard Sullivan. I represent the subject child, Faith B. Unless there are questions from the court on the other points, I'll simply address my adversary's point as to the allegedly relevant missing exhibit. The court called for written motions setting out reasons why exactly the portions of the record sought were considered relevant, and no such motion was ever made. Accordingly, that argument is waived. The portions of the record that the court did conduct an in-camera review as to was fairly broad. It covered the entire period in which the subject child was at ECMC. So that was actually in the record. So the in-camera review was conducted. No motion was ever made setting out suggesting any reason whatsoever why anything other than those dates was going to be relevant. Accordingly, the court was well justified in finding that it was nothing more than a fishing expedition. For those reasons, I submit that point is meritless. Unless the court has questions on that point or any other, I'll yield.
Thank you, counsel.
Thank you.
Your Honors, thank you. Mindy Marenka for the child Nevaeh. I too will submit on all other points and address the point that's been raised before the court. I have to agree with counsel for the child Faith that while an objection was made by respondents' counsel at trial about what portions were going to be considered by the court and ultimately entered into evidence, there was no motion made. The motion under CPLR 3101D has to be made properly for the court to consider what outweighs the child's confidentiality and need for privacy and what the trial court needs to consider. The deference to the trial court of their proper review under CPLR 3103, I think, has to be noted.
And here the court did allow in the records that pertain to the admission at the time that it's alleged that this occurred.
Correct, and did that proper identification, review, and then entrance of those. The records that were not allowed in were marked for identification. They were part of the in-camera review, but not entered into evidence. Mr. Broderick's point about those that were marked for identification not being preserved for appellate review While it's understandable, and I think that it is true in the family court world, or in probably many courts worlds, there's a space reason for that. They are not part of the record. They're marked for identification and returned to either counsel or destroyed if they're confidential records, or returned to the hospital. They are not part of the court's record. They are not part of this trial record. And certainly here, the court acted properly, both to review the records and then weigh those
There'd have
as
to be some
evidence.
sort of separate motion to preserve those records and make them part of a supplemental record or something, and that would have had to have been made before the trial court.
Correct, and it was not done.
Thank you, counsel.
Thank you.
Thank you, Your Honors. Rachel Marrero, appearing on behalf of minor children Elijah, Grace, and Joshua B. Like the AFCs before me, I will rest on my brief, aside from addressing the point about the non-preserved records. I agree with the other two attorneys for the children in that the court indicated that those records were all, as a whole, subject to an in-camera review, and that the ones that would be admitted into evidence and considered at trial were from a specific date range that coincided with the dates that of Faith's admission and when the alleged incident occurred. I agree that those other records that were not admitted by the court and were not deemed to be material and relevant would have been unduly prejudicial and would have violated Faith's right to confidentiality, because those were private mental health records regarding a child, and those would not have been appropriate in an attempt to discredit her testimony at trial.
Thank you, counsel.
Thank you.
Case 1269, Kessler versus Cheney.
If it pleases the court and counsel, Deborah Shinta on behalf of
Proceed.
Jelaine Cheney. Your Honors, there is no real need in this case to transfer custody to ensure this child's best interests. This child was
Are
doing...
you conceding that there was a change of circumstances?
No, I am not. I don't believe that there was a change in circumstances. This child was doing extremely well academically and behaviorally. He was doing well in his relationship with his father, which shows evidence that the mother was clearly supporting the relationship between father and son.
But there was a real deterioration between the son's relationship with his mother.
Yes, and what was that due to? My position is that that is due to the father's interference with that relationship and his negative attitude to the mother that was clearly put on the record.
But one of the things here is it was consistent with both parents that the child is an emotional child. It appears that there were differences with respect to parenting. What was acceptable by one parent was not by the other.
Right, and was that change a real need to change for the child's best interest? And it is respectfully submitted that the father's parenting, he was basically nitpicking to the extreme by complaining that the child didn't have sneakers that he didn't approve of or
But is
wore
the child's
sweatpants.
emotional well-being and a deterioration of his emotional state such that that is a change? Or
Well,
how he views one parent?
Well, yes, but the court has to evaluate the genesis of that change, and it's my position that the father's having 20 conversations with the son about what he wanted to do and if he wanted to live with him, and bribing the kid to come to his house with a dog.
Counsel,
and then,
all that was all testified to. What's the standard that we have to review the judge's decision at?
the standard is whether there was a real need to change the custody from a stable place to ensure the continued best interests of the child. And it is my position that the
judge who heard the testimony saw the witnesses, got it wrong, and you're asking us to say that it was wrong and it should be otherwise.
Yes, I'm saying that the burden in this case, the standard to be met was not met in this case, yes.
Okay, but the judge did do a 21-page decision laying out the factors considered, correct?
She did consider factors, but it's my position that in light of the pickiness of the problems and the standard that needed to be met when there's a stable, long-term situation, that there was an error in this case, and the judge may have considered heavily.
But you say stable. There was a contention in the petition that there was a deterioration of the relationship between mother and child, and that there was interference, at least alleged, by the mother with respect to the child's relationship with the father.
Your Honor, if I could address the interference, the record shows that after the father made that allegation, he then, in his own testimony, said, the kid returned my calls most of the time. And when I did call and I didn't reach him, he did return my calls. So that ended up being a false allegation in the petition by his own testimony.
And with respect to calls being interrupted while they were being engaged in?
His testimony was that he was annoyed that he heard the mother speaking in the background, not necessarily interfering, but that he heard her in the background during his telephone conferences, and that annoyed him.
But there was an agreement that the child was supposed to be able to speak to the father without the interference of the mother.
I don't think there was testimony that it was interfered. I think that he heard
There's
voices.
what I'm saying to you, it was understood that she wasn't supposed to interfere with calls. I'm not saying she did, but she wasn't supposed to, correct?
Correct.
So is it not up to the fact finder to make a determination as to the credibility of any of those claims?
I think that is true, but the credibility, if you take the credibility of the father, his own testimony proved that the mother did not interfere with those telephone conferences.
So if they were distracting because he's hearing her saying whatever she's saying, that's not interference by your definition?
No, I'm saying that interference would be that she wouldn't allow the telephone conferences or she would interrupt. But from my take from reading the testimony of his, he just heard her in the background, and that it wasn't necessarily obstructing that, but it was annoying to him, not necessarily the child. And there was nothing in the record to reflect that the child wasn't permitted to go into a separate room if he'd like to, if he wanted to. There was no testimony that he was being forced to be in a certain place with the mother watching. That wasn't part of the testimony.
Counsel, would you agree, though, that the court below did find your client to be incredible in her testimony and did not make that same finding with respect to the husband or the father?
I would acknowledge that, and I would say that I believe that was an error in the review of the record. I didn't find, in my review, to be overly incredible on her end, and I found many instances of the father's own testimony contradicting.
And you're
what he
asking us to
alleged.
take a look at the record and have our own independent review of the testimony and make our own determination?
Yes, Your Honor.
Thank you,
Thank
Counsel.
you.
Good morning, Your Honors. Excuse me, Randy Margolis. I represent Mr. Kiesler, and I represented him below at trial. I would submit, Your Honor, there clearly exists a sound and substantial basis for Judge Carney's decision below based on the totality of the circumstances.
And if it's a credibility issue, we're to defer to family court, correct?
Correct, Your Honor. And obviously, Judge Carney was in the best position to determine the credibility of the witnesses. I don't necessarily think that the witness credibility was as substantial an issue as perhaps some of the other issues in this case. I don't have the benefit, as Your Honors do, of seeing the transcripts from the Lincoln hearing. I can only assume that what was said to the judge during that hearing with Mr. Duschel, the child's attorney during the trial, weighed heavily on the judge's mind. I think even her written decision said that one of the weightiest factors that she considered was the child's preference to be with his father. I think if you look at the totality of the circumstances, what the judge really was focusing on, not so much as whether the dad fed the kid hot dogs for lunch or salads, but I think had to do with the emotional well-being of the child and the quality of the relationship that the child had with each of the parents. And I think it's clear
And certainly the child's, preference, depending upon age and level of maturity, is something the court should take into consideration. We can agree on that.
Of course.
But it certainly is not controlling on the court below,
It's
correct?
not dispositive, Your Honor, but the child who's going to be 15 years old a couple weeks from now was 13 or 14 during the trial, and the testimony included the fact that the mother was not allowing the child to even make his own decisions with regard to social things. She was scheduling play dates. That's what she called them.
So your
play dates.
argument is, even though she may have been a good mother to the child at the stage of his life when he was incapable of making independent choice, at this stage, in adolescence approaching, it was in his best interest that there be a change?
That's absolutely correct, Your Honor. I think that the judge carefully weighed the emotional well-being of the child as well as the physical attributes. I'll agree that the child was doing well in school, grade-wise, but not socially, not emotionally.
And even not physically entirely. There were some physical issues.
There were some health issues, some weight issues, and so forth.
Dental issues.
And there's testimony or part of the judge's decision, I think, points to the fact that when asked to discuss his mother, the child broke down and cried when discussing his own relationship with his mother. So I think that there was some serious deficiency in the quality and the nature of the relationship between this child, Peter Jr., and his mother, and I think the judge made
And
the
the
right call.
bottom line, it is the best interest of the child. It is not one parent's right superior to the other.
That's right, Your Honor, I agree.
Thank you, counsel.
Thank you.
May it please the court. I can tell from your questions you already have the issue, so I will just tell you that I've met with my client. I am not substituting judgment, that my brief and my position is in line with his position. Thank you.
Thank you, counsel. Case 1270, Southwestern Investors Group LLC versus Turco. And Adamo. Excuse me. Proceed, counsel.
Good morning, Your Honor. Sean McPhee of Phillips Lytle LLP for the appellants. Your Honors, we've raised just one argument on our brief, and I'll be very brief this morning. To plead a cause of action for fraud, a plaintiff must allege that it suffered a compensable injury. And in that regard, the New York Court of Appeals has very recently reaffirmed New York's longstanding rule, known as the out-of-pocket rule, that a plaintiff has to have out-of-pocket losses that are directly attributable to the fraud in order to state a claim for fraud. This court held as much, even more recently, in Ullman versus medical insurance liability. And Justices Curran, Peredato, and Troutman, you are all members of that panel. Here, to apply the out-of-pocket rule, we can look to the First Department's recent decision in Camiva Group versus Garda for guidance. And simply, the court there says, like all New York courts have said for 100 years, we need to look at the value of the consideration that was parted with and compare it to the value of the consideration that was received. That's how we're going to determine whether there's an out-of-pocket loss.
So here we're part of the argument is that the $440,000 investment that they made is a loss. Your argument is that even that they admit that the net collections are expected to exceed that investment, so that there's no out-of-pocket loss.
By their very own admission, Judge, absolutely correct. It's in the record at page 165. This is the plaintiff's president's sworn testimony. Now, he calls it an investment. That's a very important thing to note. This is not debt. This is an equity investment. This is, I'm going to pay $440,000, and in return, I'm going to get something that's valued at $1.4 million. They've tripled their investment. There's no out-of-pocket loss. And this calculation, it's very important to note, Your Honors, they didn't dispute the calculation below, and they haven't disputed it in their brief to this argument, to this court. So there's no dispute that they've paid $440,000 and received something worth $1.4 million. And as such, they have no out-of-pocket damages.
What about their argument that that they are stuck with some liability or debt associated with the portfolios? I think there seems to be a dispute as to who still owns these portfolios.
So you're correct, Your Honor. That's a different part of the same case. It involves a different defendant, has
Okay,
nothing to
that's
do with
JH.
my clients. That's the JH defendant.
And the causes of action against JH, or at least the breach of contract, is still alive, right?
No, that's not
So
correct.
the first cause of action against JH?
That was dismissed by the trial
Oh.
court. And in fact, recently, the trial court granted summary judgment in favor of JH as the
Oh.
owner of the accounts. But the fact of the matter is, whether or not the plaintiff here subsequently assigned accounts to JH, there's no causal relationship between that and the alleged fraud with respect to my clients.
Your two clients.
And so, and we've
Mr.
cited
McPhee,
in our brief.
Here's where it gave me a question or two. It was with respect to fraud, which is a tort, right?
Correct.
You don't get the benefit of your bargain. You get what I think is essentially rescission damages. Is that a fair characterization?
Well, what the Court of Appeals calls it is out-of-pocket
Out-of-pocket.
damages. The benefit of the bargain damages
contract.
only relates with the contract. That's
Gotcha.
absolutely correct.
Okay, but here, how do we do the math now? That is, isn't there argument that, yeah, maybe someday we're going to make this amount of money on it, but it's not worth that now? So and on motion to dismiss, how do we do the math now?
Just like you did in Ullman, just like the First Department did in Camiva, and just like the Court of Appeals did in Connaughton. We look at the value at the time of the transaction. What happens subsequently, there's no relation causally to the alleged fraud. So we look at the value, and like I said, the plaintiff's own sworn testimony says, this is what I paid, this is what I got. We compare the two, and that's it. We have no out-of-pocket loss. So if we couldn't do that, Judge, this court would have never been able to dismiss the Ullman case at a pre-answer dismissal stage, and the same with Connaughton at the Court of Appeals. So the answer to your question respectfully is we look at it at the time of the transaction. We have those facts here. In candor, Camiva was a summary judgment case, but we don't cite Camiva for the fact that the procedural posture. What we're citing it for is the formula, and we look at that formula here. It's not disputed. We have the values right in the record.
I think we have your argument, counsel. Thank you.
Sure. Good morning. May it please the court, Kevin O'Brien from Colligan Law on behalf of Southwestern Investors. Your Honor, the cases that are cited, Justice Chimes was correct in finding that out-of-pocket losses were alleged here. The cases that are cited are...
Tell me what they are. Tell me what the out-of-pocket losses are, because that's really the issue.
Well, the out-of-pocket losses at this point...
Or that are alleged.
Right. So the out-of-pocket losses that are alleged are damages, and it can change. It's a bit of a moving target at this point, because when the complaint was filed, the understanding was that the transaction constituted a loan. It's clear that it was a financing for the purpose of purchasing debt portfolios. Southwestern Investors allege that it was a loan. JH alleges that it was a sale. And so the JH has recently been awarded summary judgment on that issue. We have filed a notice of appeal. So what would constitute damages could change. It is different depending on the determination of the court whether the decision in favor of JH is upheld on appeal, or whether we would go back to the pleading stage. However, at the time that the transaction was entered into, my client relied upon the representations of the defendants who are here with respect to what constituted the terms of
The waterfall feature?
And the waterfall feature is chief among that. And so the distinction that can be made between the facts of this case and every other case that's been cited, including Connaughton, is that the damages that are alleged are not speculative and based on what would have been done but for the fraud. So
No, but aren't the damages that are alleged with respect to the waterfall feature additional profits that would have been made?
No,
based on the waterfall feature?
No, it's what would have made the transaction profitable.
More profitable, right? I mean, are you disputing that the collections that you made on that, or that are expected on that $440,000 investment, are not going to exceed $440,000?
Well, the collections that would be expected is also complicated by who owns the loans. And so that is an outstanding issue. And the issue of the transaction as it was entered into at the time is whether the money that would have been received to obtain profitability required the waterfall feature. And that is the allegation in the complaint, that in order to receive the benefit of the bargain, the waterfall feature and the enhanced collections upon reaching certain benchmarks is what would obtain the profitability. Now, also, the portfolios were valued at $1.1 million, and they were purchased at the $440,000 based on that representation. But that was based upon, and the purchase was entered into based upon the existence of the waterfall feature.
But
And
that's really, that's not out-of-pocket loss. That's benefit of the bargain loss, correct? The waterfall feature and the breach of contract? I'm following up on Justice Peridotto's question. I mean, you know that your amended complaint right is bare bones in terms of damages. Would you agree with that?
The complaint that is, yes, the complaint that is in front of this court is.
Bare bones on damages. Okay. But you get to supplement it with the affidavits, right? And in those affidavits, where do they argue the out-of-pocket rescissionary type loss under fraud?
I'm sorry, I didn't hear you.
Where do they where in those affidavits is that rescissionary type out-of-pocket loss? Where is that in the affidavits?
I don't agree that it's our position that the court granted the motion to dismiss or denied the motion to dismiss based upon the face of the complaint. So our position is not that we need to look at the affidavits in order to reach this conclusion. The complaint as it is drafted states a cause of action for fraud, states a cause of action for out-of-pocket damages based upon the losses incurred, based upon the losses incurred as a result of the fraud. And it's different than all of the other cases that have been cited in that, for example, in Connaughton, there was a chef who was claiming that if he had entered if he had not entered into this agreement, but for the fraud, he had other business opportunities. That's not what we're arguing here. The same is hold true for Barrett. Barrett was a textbook case of trying to time the market and look backwards and say, if I would have sold at the height of the market as opposed to where they were. Those are completely different facts from what we have here. What we have here is an agreement that was entered into based on a fraudulent inducement from the defendants who are here, and the damages that flowed from that came through that contract.
Thank you, counsel.
Thank you.
Case 1271, Schubauer versus 2150 Recycling Center, Inc.
Good morning. May it please the court. Kevin Krupa for defendants, appellants, 2150 Recycling Center and M&M Appellate. In this case, the plaintiff signed a waiver to go onto defendant's used auto parts lot and pull parts after walking around the lot and finding what he wanted. The waiver, defendants allowed their customers to go onto their lot in exchange.
Doesn't the waiver just pertain to looking at the cars and picking out the equipment, like climbing over a car, that kind of thing? But does it really apply to a slip and fall?
Sure it does, Your Honor.
Why?
I mean,
Where is that?
in order to find the part you want, you have to walk around on the lot. And you have to find the car that you want, walking around on the lot, and then pick out the part you want. And here, if the plaintiff had claimed that he slipped and fell on fluid that had leaked from the cars, there'd be no question that the waiver applied. Here, he just claims that he slipped and fell in snow on ice. And he had signed this waiver on multiple occasions before he went there on the date of the accident. His testimony was that he understood what the waiver meant. He knew it absolved the defendants of liability, but he signed it anyway based on his prior experience to go on the lot.
If we decide, the issue is we have to decide whether this accident is within the scope of the waiver. That's the issue, correct?
Yes.
Okay.
So the waiver says that automobile salvage yards present certain risks. And you're saying that that waiver encompasses kind of garden variety premises liability risks like snow and ice?
Yes, Your Honor. Because It says, the waiver also says resulting directly or indirectly from the negligence or carelessness of M&M Appellate Incorporated and the owner.
So I take it there isn't sidewalks going through or a defined path, it's just stuff piled up around in pathways?
I believe there are defined paths, but there are no sidewalks. And those are maintained, but this is open to the elements, it's open all year round. The
But
plaintiff
you
had
don't
the,
plow them to the full extent, you do something with what, a high lift? If the ground's uneven, you don't go through and salt it? Is that my understanding?
the grounds are maintained, they are plowed, but, you know, the customers have to sign the waiver in order to get onto the property when they go on there during any time of the year. Here it was March in upstate New York, and the plaintiff's own testimony was that he was aware of the weather conditions when he went out there. He chose to go out there, sign the waiver, and access the lot.
You agree that liability waivers are generally frowned upon and subject to pretty close scrutiny by us?
I do agree with that, but here I think the language in the waiver is unequivocal, and the waiver certainly doesn't violate any of the provisions of the general obligations law, specifically the provision waived here of the recreational statute, where here the plaintiff isn't, you know, engaged in, you know, riding a go-kart or tobogganing or anything like that. He's signed the waiver to gain access to the inventory of defendant's lot, and I would submit that this case is similar to the Ward versus Dunn case, where the waiver was upheld, where the plaintiff signed the waiver in order to use the tanning bed equipment. Here, the plaintiff is accessing inventory. In that case, the plaintiff is using the defendant's equipment, and in both cases, the waiver was upheld.
Anything further, counsel?
That's it, unless the court
Thank
has
you.
any other questions. Thank you.
Scott Duquin.
I take it you agree with your opposition here that the key issue is whether this injury or this accident falls within the scope of the waiver?
Yes, Your Honor, and I think it's outside the scope of the waiver. The waiver specifically mentions automobiles and what goes on.
The first paragraph talks about the subject matter, you would say, right?
Correct, Your Honor.
Okay. So what we really have to do to sum it up, right, is this court has to look at the waiver and figure out whether it applies. That's it.
Yes, Your Honor, I would tend to agree with it, and the second sentence of the waiver is examine or retrieve auto parts. Here, I mean, what the condition is it's a trap. The testimony was that you walk into the place, it's a fenced-in place, you got to pay $2 to even gain access. That's what makes the general obligations statute applicable here. I mean, recreation is broadly defined in the statute. And I would assert somebody...
So, wait. I'm really having a hard time saying that when people go into a salvage yard, they're engaging in some sort of recreational activity. I mean, even though I'm not a motorhead, I don't get it.
Well, but Your Honor, he wasn't there for a commercial purpose. He was there to get a used windshield wiper motor for his girlfriend's
Exactly. How is that
car.
recreational activity?
You don't need that argument, do you, sir?
Right.
No, I don't.
Right. Don't go there.
All right. Well, at least we're having fun. On the first point, it's outside of the waiver.
But it says, in consideration, he is allowed to enter upon the premises. So that, he's there.
But he pays $2 to enter upon, and the condition is a trap, and that's what I was trying. There's a trailer. They plow that area, they salt that area. Then there's rows of cars, and I would assert they're stacked in rows so that there's some rhyme and reason to it, and you can actually find the different vehicles. But on page 140, I want to be specific, 144, he notes ruts, snow covering. There's snow on top of a rut, and that's where the ice was. So he identified what he fell on. He's military, he's wearing military boots, he's appropriately dressed. He's walking in a part of the yard where they've plowed, but they haven't salted. So he sees snow. He takes his step, he slips, and from his testimony, it's clear that he fell through a rut.
Yeah, we're familiar with the facts, and the idea, as I'm looking at this, and what we have to decide is, does the waiver intend to cover the activity of going into the cars, climbing over the cars, trying to find the equipment that you want, or does it also include not only that, but the actual ingress and egress through this particular area?
The waiver does not cover the ingress and egress.
And we'll look at that.
Thank you.
Thank you, counsel.
1274, Thomas Johnson versus the Town of Hamburg. Presiding Justice Whalen is recused from this case. Okay, you may proceed.
Yes, good morning, Your Honors. May it please the Court. Sean Hopkins on behalf of the respondent, Glenn Wetzel. The issue that's before the Court this morning pertains to the sufficiency of a legal notice published of a hearing held by the Town of Hamburg Town Board in its legislative capacity on November 9th of 2015 in connection with the request to rezone a portion of a vacant parcel. The lower court held that the legal notice that was published did not comply with the legal requirements for two reasons. Number one, it cited that it misled the public into believing they had in fact filed a valid protest petition pursuant to New York State Town Law Section 265-1 when they hadn't. And secondly, cited to a letter from the town attorney, the then former town attorney, stating that in his opinion, since the requested rezoning had changed the very evening of the public hearing, that would be appropriate to refer it back to the planning board. So in terms of the legal sufficiency of the notice, the key case is the Granat case, the Court of Appeals case, which basically states as follows. Notice must fairly apprise the public of the fundamental character of the proposed change and must not mislead interested parties into foregoing attendance at the public hearing.
Did the petitioners make it to the hearing?
Each of the four petitioners attended the public hearing. Each of the four petitioners had attended countless of the previous planning board meetings and town board meetings. There were a total of 18 of them. The rezoning itself, while the town attorney's office, the very same one that complained about the legal notice, published a notice that did incorrectly state what the acreage to be rezoned was, it had changed nearly a year earlier. That change resulted from input from the petitioners, who asked my client to reduce the density of the project, asked my client to provide more permanent open space.
There were a number of updated submissions that were made during the course of almost a year.
A two-year process.
2 year.
And in each and every instance, when there was an update, it involved lowering the number of lots, reducing the density, and increasing the amount of permanent open space, and providing larger buffers for the residents, including the petitioners. So we think it's quite clear that the petitioners were there. We think it's quite clear that while the legal notice was correct, if you actually look at the transcript of the public hearing, again and again, the correct acreage is restated. The petitioners allege, well, we really were harmed because if we had known in advance of that evening that we did not have valid protest petitions, we could have handled things differently. We could have gone out and obtained more signatures. There's a real quick and easy response to that, and that is the town board did not vote the night of the public hearing on November 9th of 2015. It voted 5 weeks later. And pursuant to New York State Town Law Section 265-1, a valid protest petition can be filed right up until the moment the town board votes. So they still had 5 additional weeks to go out and solicit additional input from neighbors. It is important to note that there was support from the project as well. The public hearing, there were 5 people in favor, 5 people against. We think it's quite clear that the town board exercised its legislative discretion, acted properly. We do acknowledge there was a minor mistake in the actual notice. The petitioners were there. They knew the acreage had been changed more than 10 months earlier. The planning board itself, in issuing its recommendation, recited the reduced acreage based on the modifications. And then the final thing I want to touch on is while the court limited its ruling to that issue, we have asked you to consider the other points that have been raised by in connection with the appeal. So I want to address those quickly.
There are at least 3 other issues that were raised in the petition that were not addressed by the court.
Yeah, which if you would allow me
Yes,
the opportunity,
please
I'd like to address very quickly. The second was a claim that the town board failed to comply with the State Environmental Quality Review Act. As this court is aware, Apkin versus Koch, Jackson versus the UDC, it's a very deferential standard to the town board acting in its capacity as the lead agency. The petitioners cite to the fact that the Planning Board and the Conservation Advisory Board raised some environmental concerns. That is true, but ultimately the town board, the one who accepted lead agency responsibility, is responsible for the seeker determination. If you look at the record, which obviously is more than 1,000 pages, there are countless studies and reports, traffic studies, archaeological reports, wetland delineations, analysis of community character, landscaping plans, drainage plans, et cetera, et cetera. I think it's quite clear the town board complied with seeker. Petitioners also say, well, the negative declaration that was issued by the town board really did not contain a reasoned elaboration, and in fact, the form they used was wrong. Well, there's a simple response to that. In November of 2013, the New York State Department of Environmental Conservation promulgated new forms to be used in connection with environmental reviews pursuant to seeker. Those very forms were used. It was signed by Supervisor Walters at the end, and if you look at that Part 1, Part 2, and Part 3 of the EAF, they total nearly 30 pages. They have very detailed reasons in support of the town board's position. The additional claim was that there was no referral to the Erie County Planning Board.
That doesn't exist anymore.
There is no Erie County Planning Board. There hasn't been for some time. It was referred to the Erie County Department of Environment and Planning pursuant to New York State General Municipal Law Section 239M, and also the Erie County Department of Public Works, Erie County Division of Sewage Management, and all their comments are in the record. And the fourth claim deals with consistency with the comprehensive plan, and as this court is aware, that is a very heavy burden on a petitioner unless they can demonstrate a clear conflict with the comprehensive plan. That's not a valid reason to overturn the legislative decision. You have the affidavits from the supervisor and Councilmember Potter Judah, and if you look at the actual record, the comprehensive plan is there, and there are numerous citations to why this particular rezoning to accommodate 45 lots on 30 acres with nearly 60% designated as permanent open space is consistent with the comprehensive plan. Thank you.
Thank you, Counsel.
Good morning, Your Honors.
Good morning.
My name is Richard Lippis, and I represent the petitioner respondents, and it's nice to be on this side of the table for a change. The first issue I'd like to address is one that the court did not address, and we believe that that issue is dispositive of this appeal, and that's the violation of 239M. As my friend, Mr. Hopkins...
Because they didn't send it to the Erie County Planning Board, that argument.
No,
Is
yeah,
that,
that
no?
argument. And
Yeah.
there's no planning board. He's right about
Right.
that. But they did send it, where there's no planning board, they sent it to the planning agency,
Right.
which they did here. They sent a one-page form, but Section 239M requires them to send to the planning board or agency a full, what they call a full statement of the proposed action, which includes, and the only thing that's specifically mentioned, is the environmental assessment form. They did not send the environmental assessment form. That is a clear violation of Section 239M. In fact, they sent nothing other than one page, the one-page form that they filled out. They
Didn't they?
send-
I thought they sent all the kind of seeker-related materials. They didn't do that?
It's not in the record. It's not alleged in the brief. And as far as I can tell, they did not send it. And there's no allegation that they did. That is a violation of Section 239M, is a jurisdictional defect. And that, as I say, in and of itself, is dispositive and supports the judge's remedy, if not her reasoning, since she didn't deal with that issue.
She didn't address that issue, right?
Yeah. The second issue I'd like to address is the seeker issue. A negative declaration was issued by the town board, and this is a classic example of everyone being out of step but Johnny. In this case,
You say it should have been considered a type 1 action, right?
first of all, it should have been considered type 1.
But didn't they really almost treat, even though they issued the negative declaration, didn't they really treat it as a type 1 action? And
Well-
do really all of the kind of reviews that you do with a type 1 action?
They did part 1, 2, and 3 of the environmental assessment form, which is required. But the importance of a type 1 action is that it creates a presumption that there will be at least one or may be at least one significant adverse environmental consequence.
Impact.
And that presumption obviously can be rebutted, but in this case, we don't, the town board, we don't know if they presumed that there would be an adverse environmental consequence because it was never designated as type 1. So that presumption was never included. Moreover, it's arbitrary and capricious for to assume that that presumption has been rebutted when both the Conservation Advisory Committee and the Planning Board, and the Planning Board has the most expertise in this area, both very vigorously indicated that, well, the Planning Board actually specifically indicated that there were seeker issues that were involved here and indicated that an environmental impact statement should be drafted. And both agencies indicated the adverse environmental effects if this project goes forward. This is an area where there was actually an overlay district that was passed by the town. In other words, they pointed this area out as one that had important vistas to the town, and both the Citizens Advisory Board and the Planning Board indicated that those vistas would be adversely affected. So that violates the arbitrary and capricious standard where the town board simply ignored everyone else. Finally, in terms of the hard look standard, which includes the necessity for a reasoned elaboration, the regulations and the DEC and the seeker handbook specifically indicate that while the law, the regulations were amended to allow a negative declaration to be the environmental assessment form, that doesn't mean that the environmental assessment form provides the reasoned elaboration. The reasoned elaboration is a written document that discusses why the particular areas of potential environmental effects that were identified and supposedly taken a hard look at did not, in fact, provide a significant adverse environmental consequence. At the end of the environmental assessment, there were 2 pages that dealt with the issues, all in a conclusory fashion. In other words, they said things like, well, there won't be a problem with the vistas, or without giving any reasons. That's what a reasoned elaboration is, not just conclusions.
And you're saying that's what establishes that they took the hard look?
Well,
when they tell us what the reasoned elaboration is, that's what establishes that they took the hard look?
Well, the whole record deals with the hard look. The reasoned elaboration establishes the basis of their decision that they didn't have to do an environmental impact statement because there will be, not that there will be no significant adverse environmental consequences. And the court can't even review that decision without having the reasoned elaboration in front of them. And it is a specific requirement of the hard look standard. And if it's not included, again, that's a violation of seeker. Now, the next issue that the court also didn't deal with is the issue of whether or not the decision to approve this project was consistent with the comprehensive planning document of the town of Hamburg. And again, the agency that basically wrote that document and that has the most expertise in interpreting the comprehensive plan is the planning board. If any deference needs to be shown here, it's deference to the planning board itself in interpreting the document that they prepared, and they specifically indicated that this was not consistent with the comprehensive planning document in their comments to the town.
I don't see where the petitioners here specified what sections of the comprehensive plan were violated.
The planning board in their comments.
No, I know about the planning board, but in the petition, I'm talking about what the petitioners, what you allege.
We referenced
the planning board.
The planning board and their determination. for those reasons. And then finally, the one issue that the judge did deal with, and that is the public notice issue. The public notice goes to the public, not just to the petitioners. The petitioners knew that there was one member of this three-member town board that was opposed to this project. They prepared a protest petition, which would have been effective.
So that's the issue about the supermajority?
Yes, exactly.
And your attitude is if they knew one was against it and a supermajority was required, then the project was dead?
That's right. They needed all three votes. That's why this whole movement of reducing town boards probably is ridiculous, but that's an aside. In this case, the judge determined that under the standard of requiring that the public notice advises the public of what is going to be considered at the hearing, provided incorrect information. And there's no dispute about that. The public notice said that they were going to consider 29.9 acres in this project. And in fact, it was 24.9 acres, which meant that the protest petition would not have been applied. And we don't know, and it would be pure speculation, whether or not members of the public that received that notice would have attended if they knew what the appropriate project was. And
But the petitioners here were all present.
the petitioners were present.
All right.
The petitioners were very active in this matter. But again, on 239 alone, that's really dispositive. Thank you.
Okay, thank you, counsel. 1276, Sims versus Saccone, Burton, and Saccone.
Good afternoon, Your Honors.
Please proceed, counsel.
Yes, John Collins for the plaintiff appellant Jennifer Sims. And on Ms. Sims' behalf, I assert that the Supreme Court erred in three respects in its decision and order. First, in dismissing plaintiff's claims under the significant limitation and permanent consequential limitation components of the no-fault law. Secondly, in denying plaintiff's cross motion for partial summary judgment under the no-fault law's 90 out of 180-day category. And third, in denying plaintiff's cross motion for partial summary judgment on the issue of defendant's negligence.
Let me just ask you about 90 out of 180 day.
Yes, Your Honor.
There's no question that there was proof that the plaintiff couldn't work. But the statute refers to all of your usual activities, and I'm not so sure that there's much in the record about her other activities.
Well,
or other kind of daily activities, and so I'm wondering whether a jury should decide that.
I think that comes, Your Honor, from her testimony, which I think is completely consistent with the
But there's no medical testimony. The doctors do say she's out of work, they've left her out of work, she shouldn't go back to work. But none of the doctors who treated her actually say she's unable to participate in they never refer to activities of daily living, do they?
They did not, but I think what they did refer to her, and both of the doctors, her treating chiropractor and her treating orthopedic surgeon, talked about the level of limitations resulting from both cervical range of motion losses and lumbar range of motion losses.
But she didn't testify she had to bring in a housekeeper to do cooking. She was still able to take care of her children. Those things weren't specified. She said, I didn't play competitive softball or other things. I mean, she did say they're limited in certain ways, but I'm not sure she said enough about activities of daily living.
I thought she did, Your Honor, and I would submit that she did by talking about just being able to do.
But the court said you get a trial on that issue.
The court did say you get a trial on that issue.
So you certainly think he's that far right, should go further, but you have no problem with having a trial on that issue?
Well, I submit that we established our entitlement to summary judgment on the issue.
As a matter of law. You say it was established as a matter of law.
As a matter of law, based upon the medical proof
testimony,
combined with her testimony as to the very significant limitations that she undoubtedly had as a result of this, and, you know, couldn't even do any sort of work for well over a year beyond this until she was finally released and told, find a new occupation, you're never going to be on your feet again for, 40 to 70 hours a week, as she had been. Do something sedentary with a lot fewer hours, which is what she wound up doing a year and a third after her accident. And in that same period, she was limited, as I said, based on her testimony, in just about every aspect of her normal life in terms of
But then you say the
yard
judge
work.
got it wrong about permanent, consequential, and significant limitation. Why is that? What tells us the judge got it wrong?
Two things, Your Honor. First, I think that just from the beginning, from the start, defendants failed to establish their entitlement to summary judgment on that issue. They relied solely upon the report of Peter Capicato, MD, who, in his report, indicated that plaintiff had, when he measured her virtually 3 years to the day after the accident, 44% range of motion losses in the cervical, right and left bending, which he attributed to strain rather than any sort of discogenic injury, contrary to what the treating doctor said. Dr. Capicato, in his...
But are you saying that that wasn't enough to carry their burden and to shift the burden to you with respect to those issues?
No, Your Honor, for this reason. He did not, in attributing the range of motion losses in the cervical neck, dispute that there was a link with the motor vehicle accident. He merely said, I don't think it's disc-related, I think it's strain. But in my brief, two briefs to this court, I cite 3 cases where this court has held that strains, sprains, spasms that result in significant range of motion losses do constitute objective proof of physical injury, and when combined with those losses, certainly raise a question of fact.
Did Capicato ever address the fact that she didn't have prior complaints or prior medical treatment of this condition?
He did not, and that is one of the 3, I think, significant factors that established that Dr. Capicato's report was just prima facie insufficient to establish the defendant's entitlement to summary judgment on significant limitation and permanent consequential, because in this court's decision in N.Y.S, Thomas versus Ha, the court held that where a defense medical examining doctor concedes that there are physical limitations, but fails to account for the fact that plaintiff was utterly free of any such pain and limitations before the accident, the defendant has failed to meet their threshold burden of proof.
So you think that's a question of fact, and we should put those back in?
That is a question of fact. And thirdly, I wanted to point out one other factor regarding the insufficiency of the defendant's motion proof, which is, in addition to the cervical ROM loss, the examining doctor stated that the lower back, plaintiff's lower back condition was very limited, her range of motion. He attributed to muscle spasms and myofascial disease, and he said that is, quote, possibly consequential to the motor vehicle accident. The fact that, in his opinion, there was no disc problem, again, is not controlled.
So he's, just by the speculation there, he's raising a question of fact for a jury to determine, and that's why it should be left back in.
Exactly.
All right, very good.
And even if the court
You should begin to wrap up, counsel.
Yes, Your Honor. And even if the court were to find that defendant satisfied its threshold burden, plaintiff through the records of Dr. Huckle, which are admissible because they were referred to by Dr. Capicato and the affidavit and records by Dr. Cardamone, the chiropractor, raised questions of fact on those two disputed categories. Finally, plaintiff submits that the trial court erred in denying her motion for summary judgment on the issue of defendant's negligence. In the rear end case, as the court is well aware, the fact that one vehicle rear ends another that's either
So
stopped.
what excuse did she give? What reasonable excuse did she give for rear-ending your client when they were both stopped at a red light?
Her excuse was, I saw some movement, hit the accelerator. I don't know if the traffic light was red or green because I didn't look up. And I never saw her brake lights come on because the next thing I knew we had collided.
And you're
Not
saying
a reasonable excuse.
that's not a non-negligent?
Not a non-negligent explanation.
We understand. Thank you.
Good afternoon, Your Honors. Taking the plaintiff's last point about the negligence issue
That
first.
would be a great one to start, Counsel. I'm curious as to
Yes.
where in the transcript or the record does your client ever say there was a sudden stop of the vehicle in front of her?
My client stated, Your Honor, that the plaintiff moved forward and then stopped, that there was nothing in front of the client that she could see from her vantage point that
But
would
your
indicate.
client said she had her left turn signal on. Wouldn't that anticipate that perhaps there's a stop, even if there's nothing in front of them? It could be traffic coming the other way. I mean, this is a pretty busy intersection.
And it would be ideal if those facts came out during the deposition, Your Honor, but those questions were never asked and the answers were never provided. What you have is a plaintiff who says that she.
Well, do you have the burden of demonstrating a non-negligent explanation? In other words, if it's a rear-end accident, who has the burden?
We have the burden, we have the burden, Your Honor, and it's our position that the testimony alone of the two individuals involved in the accident, the plaintiff and the defendant, established the existence of a question of fact on the sudden stop defense. My client states that the vehicle in front of hers started to move and then suddenly stopped.
No, that's not what
No.
she said. That's not what her testimony is. She said that they moved, and then all of a sudden there was a collision.
The word sudden stop is never in the transcript that I could see about coming from your client.
She doesn't mirror the legal standard. You're correct, Your Honor. She does not say sudden.
No.
She doesn't say there was a sudden stop. She does say that the two vehicles were stopped, one in front of the other. The lead vehicle started, that she progressed as she saw the lead vehicle start.
And she says, I thought the car in front of me began to move. Does that even make it clear that she was moving or that she did something because of the plaintiff?
Well, the plaintiff admits that she moved. So there's no question.
One car length.
You're correct, Your Honor. So a vehicle that's at an intersection moves one car length, which should bring the vehicle somewhere into the intersection. And
Unless you believe her that she had two cars in front of her, so she's three cars back from the intersection.
And that sounds like a question of fact again, Your Honor. What
But
you have is,
but the other driver does have a duty to see that which is there to be seen.
yes, you're very right, Your Honor. Our position again is that the vehicles were situated as our client testified they were, that the plaintiff departed from a stop position, began moving forward, and then stopped. Our client began moving on seeing the lead vehicle move and was surprised and caused to rear-end the plaintiff's vehicle.
Counsel, why don't you move on to your next point?
Not to quibble with the New York State legislature, but it's a
Good
little,
idea.
It's a little difficult when you have a plaintiff who's making claims associated up and down the spine, and all of the claims are supposed to relate to one category of injury. So the court has done a nice job, I think, of unpacking. You have complaints that relate to the cervical spine and complaints that relate to the lumbar spine. Dr. Capicato, in reviewing the plaintiff's complaints as they relate to the spine, found a couple of issues with the treatment records and the plaintiff's inconsistencies in the representations about the areas of the spine. With respect to the cervical spine, She has complaints that radiate down the left-hand side of her body, but she has a bulge that emanates to the right. He says that, well, that doesn't make a great deal of sense given the distribution of her complaints. Moreover, he says that there is a dermatonal complaint that would associate with C5. However, the plaintiff's herniation or bulge is located at the C6-7 level.
Is it addressed that there were no complaints before the accident?
I don't believe that they were, Your Honor, directly. There is some discussion about the imaging studies being age appropriate and there being no evidence of any kind of acute injury. So while there were no pre-accident complaints, that would then call into question whether, in fact, there's anything in the medical record that substantiates her ongoing subjective complaints. And what we have found is that there is a real inconsistency, which was offered more elaborately, I should say, in the opposition to plaintiff's motion. If you take a look at the chart of her range of motion deficits.
But there's going to be a trial anyways. You're not appealing from the 90 out of 180, are you?
We are not appealing from the 90 of 180.
So we know that it's going to trial at least on that issue.
Yes.
You say it should not go on the other two issues.
It should not go on the other two issues, Your Honor. And specifically with respect to the complaints that relate to the cervical spine, you have a fusion surgery that, again, was performed at C6-7. The distribution
You
of...
say the dermatomes aren't consistent.
They are inconsistent.
It might be inconsistent with C5, but not with C6-7. So
Well, no, the other way around, I'm sorry, Your Honor.
Okay.
If she had had surgery at C5, C4-5, it would make all the sense in the world that there was a herniation at that level and that there was impingement on the foraminal space and that there was some disruption in the signal going into the arms that would account for the radiculopathic complaints that she has. But that is not the case. What you have is a complaint that associates to C5, C4-5, but instead you see objective evidence of some type of a condition at C6-7.
The other levels. Mm-hmm.
That's the kind of breakdown that you're faced with. So, and again, this is where you have a question about how do you unpack this in the context of the significant injury statute or the serious injury statute. Does it actually create the limitations that the plaintiff is complaining of? Now, of course, the court will note the statute says nothing about herniations, says nothing about pain, says nothing about fusion. It's completely silent as to that. It's quantitative and qualitative in nature. So when you're looking objectively at the medical evidence and trying to find out where you have a plaintiff who's making subjective complaints, how do you explain why this person is complaining of range of motion limitations in her neck or her back, but there's nothing objective that supports her contention?
I think we have your argument, counsel.
Thank you.
Thank you. Case 1277, Seraphin Properties LLC versus Amore Enterprises, Inc.
Good afternoon, Your Honor. Guy Agostinelli for Seraphin Properties, Inc. With me today is one of our associates, Dan Bobbitt, who's been working with me on the case. You know, I've been looking at this case for quite some time now and getting ready for the argument, and the only thing I can come up with as an opening statement is that you use a driveway of your neighbors for 24 years to get your access to your parking lot, your access to your truck dock, and for that, it's twice.
Is that the only access, and does it matter if it isn't?
It does very much so, Your Honor, because that is the only access to our truck dock doors that are on the east side of our building. The photographs at the record 581, 587 show this, and it's not in dispute. That's the only way we can get to those truck docks. The building was built, don't ask me why, 36 feet from our property line, and with these doors, and that is the only access to these doors.
Okay, but really the issue here, which was the issue at trial, is whether the use of this driveway was permissive or not.
Correct. Yeah, absolutely, Judge.
And this was a
what's the
non-jury
standard?
trial, and the court found that it was permissive, that permissive use had been given to the plaintiff and to the plaintiff's predecessors for a long time.
Very, very key, Your Honor, is the type of permission that has to be granted. Permission has to be expressed based on this court's decision in Reed versus Piedimonte. It has to happen during the prescriptive period. The prescriptive period started on January 31st of 1990. 10 years later, the use is still there, and you have a prescriptive easement. And according to the DeLeo case from the Court of Appeals, the only way you lose that prescriptive easement is by either a deed or an agreement sufficient to satisfy the statute of frauds. So when Your Honor just mentioned that permission was given to my client, alleged to have been given to my client by Mr. Guy Motokamori of Amori Properties, my client didn't purchase this property until 2005. In 2005, the prescriptive easement had already matured and had already ripened into an easement right. So whether he comes to him after the prescriptive period and says, oh, feel free to use my driveway, that doesn't matter, because
But that isn't what Judge Walker found, is it?
No, what he did
And what
is he looked
standard of review do we use on Judge Walker's findings in a non-jury trial?
In a non-jury trial, the court is to examine the whole record and can come up with, based on the cases we've cited in our brief, can come up with and do what the judge should have done. And in our, it certainly has to give deference to some credibility issue. If somebody was testifying that the light was red and the other one was saying the light was green, I get it. But that's not the type of credibility issue we have here. The court looked back to the time period when the prescriptive period was running. That's between 1990 and 2000, and said, what happened there? And the court looked at three things there and then looked at three things afterwards. Well, the three things afterwards are irrelevant, because once you have the prescriptive easement matured and ripened, it can only be defeated by an instrument in writing sufficient to satisfy the statute of frauds. So let's look at what happened pre-time.
Is it the mere use during that time period that you just referred to? Is it the mere use of the driveway by your client's predecessor? Is that enough to establish the easement, the mere use of it?
Absolutely. If the use is open, notorious, as it was on a daily basis, and it continues for the period of 10 years, we're entitled to a presumption. That the court got right. The burden of proof here was on Amori to prove that something happened in that 10-year period where there was permission. And in the Reed case, this was the key case in this department, and in the Reed case, this court held that that permission has to be expressed. It can't be implied. The idea that there's a neighborly accommodation is out the door in this department based on the Reed case. You have to have expressed permission. So when counsel knows this, everybody knows this. When they tried to prove the express permission, they really didn't have any kind of proof. To defeat this type of a right, in my mind,
When did the defendant acquire the property?
The
Was it
defendant,
97?
1997.
And wasn't there some sort of village board meeting?
I was getting to that, Judge.
Right?
Thank you.
And wasn't there clear permission given at that board meeting because there was concern that they would be cut off? Keystone was concerned with it. Everybody was present according to the testimony. Couldn't the trial court credit that testimony and construe that as express permission, even if assuming express is necessary? Isn't that enough?
No, I don't. In this case, the court did look at that testimony. But what I think this court needs to do is look at what happened at that testimony. That testimony was made by a person who expressed at trial that when he wanted to acquire this property, he wanted to make sure that nobody could use that driveway. He testified to that at trial. Then he went on, is it credible for that person to then testify at a village meeting that I gave permission to all of the industrial park owners, including my predecessor, Keystone, to be able to use that. Now, is that credible when
That's a
the
credibility
person...
determination, right?
Well, hang on a second, I'm not done. Is that credible when the person who states that cannot identify a single person at that meeting? He cannot say when that meeting occurred. And from a legal standpoint, as we've cited in our brief, the meeting occurred prior to the time they acquired title, and he could not say, and therefore, it's, as far as I'm concerned, it's legally insufficient. But he could not say who was there.
If we disagree with you that, that express permission is not the standard, that implied permission is enough, would you agree that there's adequate proof in this record to support the conclusion that permission was proven?
I don't
or
think so,
permissive use
Judge.
was established?
You know, I wouldn't, because here's the thing. You've got somebody, I appreciate the question, it's a good one, but you've got somebody that is in a driveway. He's there every single day. He watches somebody pull in and out. At times, as you can see from the pictures in the record, there's a tractor trailer that goes right across the driveway and deprives everybody the right to use that driveway. I think that the fact that there's some implication that he's letting that go, if Your Honor was correct, you would never have a prescriptive easement case. Because in every case, the neighbor could come forward and say, well, I never objected to it.
So you're
It's
saying
implied.
the evidence of arguably neighborly cooperation is irrelevant?
Yes, Your Honor. What you have to do is you have to look at this department's case and Reed versus Dept. And this department said...
But again, as Justice Perdomo said, if we believe that there is evidence of an implied easement, don't you then look to the relationship of the parties?
I think that would be true, but then you would have to overturn this court's decision in Reed versus Dept. Now, in the Reed case, it goes twofold. Number one, it says the permission has to be expressed. But number two, the follow-up to that in the Reed case was that proof of a neighborly accommodation does not provide express permission. So I appreciate the theoretical question, but it's not our facts and it's not our law in this department.
Counsel, you should wrap up.
So the other stuff that was talked about, there was some letters that were exchanged. I found
What about
those
the
all
practicalities?
inconclusive.
Mr. Gosnelli, excuse me one second.
Yes.
What about the practicalities here? Was there any proof in the record as to what it would cost to repair, maintain this property on a cooperative basis?
Oh, sure. Judge, there was. It would cost about $80,000 or so. There's proof in the record about estimates the guy, Motokamori, from Omori Enterprises had obtained. The parties were talking about doing that. My client would gladly pay his fair share. He said it over and over again. It's in the record. He has to by law. He'd be happy to pay his fair share of the costs incurred to repair this driveway. In fact, the parties were repairing it all along in these past 20-some-odd years. There would be snow plowing, there would be some asphalt patching, there would be removal of stones, things like that. So all of that was done, and my client by law would have to contribute to that, and he said he would be happy to.
I thought that number, his share was 23,000 or so.
Pardon me?
I thought his share was 23,000 or so, was what he was asked for.
No,
Okay,
his
I'll look at
his share would be whatever percentage of the cost would be applicable. So if it costs $75,000, 3 buildings using this property driveway right now, his would be 1/3 of it.
Great,
If
thank
it costs more, it'd be 1/3 of that. Thank you.
Counsel.
Your Honors, may it please the Court, Kimberly Thrun for the defendant respondent in this matter.
Your opponent seems to, really seems to rely on the fact that the permission has to have been expressly given.
And I believe that's where the fallacy in the plaintiff's argument lies. If you take a look at the Reed case, I believe it's a 1- or 2-page case, it's very clear in that case that in that specific instance, the claim of implied permission lacked merit, and express permission wasn't proven. It doesn't say that you need express permission and implied permission is never the case, and I think that's belied by the case law
That
from
follows.
various different departments that's extensively cited in my brief, that certainly implied permission is valid and is a way to prove or disprove a prescriptive easement. And I can quote that neighborly accommodation, willing accord, or convenience tolerated will not be sufficient to establish a permanent right. That was cited by the trial court in its decision. I just think that it's completely incorrect, and I think it's a misconstruing of the Reed case in this regard. So both misconstruing the law of that case, which is in this department, and then not taking into account the law that comes from other departments.
Yeah, the problem in Reed is there just was insufficient evidence of both, of express and implied.
Correct, and in this case, it's totally an opposite. There's evidence of both express permission in the defendant's predecessor, those correspondence between the attorneys indicating that permission was granted, indicating that they want to be good neighbors with one another. In addition, the cited village board meeting that my client attended, and again, at this point, that was about 20 or so years ago. And he testified to that consistently, multiple times on the record. His testimony was interrupted, and in my brief, I do cite to all the instances where he consistently testified that representatives from all of the adjoining businesses, specifically Keystone, was there, that he discussed this matter with Keystone at a later date after that meeting. And consistently, when the plaintiff took ownership of the property, he went to the plaintiff and then discussed it with him. So although that occurs outside of the alleged prescriptive period, I think it shows a pattern of my client asserting his ownership rights, indicating permissive use. And it's very true. These buildings were built very close to one another, and the businesses have cooperated for a number of years. And that's more than neighborly accommodation. These are huge trucks going through this property. They've cooperated not only in just the general flow of traffic, but also in maintenance, in snow plowing, in other instances. They patronize each other's businesses. And if you take a look, there are significant cases where the facts are very analogous, including the case cited 2239 Highland Boulevard on page 31 of our brief, which the fact pattern is so strikingly similar with regards to implied permission. With regards to express permission, I believe it's even stronger in the case at bar. Your Honors asked about the standard. The standard cited on page 13 of my brief. And generally, the decision following a non-jury trial should not be disturbed on appeal unless it is obvious that the court's conclusions could not be reached under any fair interpretation of the evidence. And that's the standard before this court today.
Very good. Thank you, counsel.
Thank you.
Case 1278, Mecca versus Puff Pat. Sure I got that. Proceed, counsel.
Thank you, Your Honor. The microphone appears to be drooping, so if you can't hear me, just let me know. This is a case of, my name is Tom Cunningham. I represent the appellant defendants. This case is a case of animal liability. And in animal liability, the standard is vicious propensities, which we know is the propensity to cause harm.
So your point is, at a minimum, the negligence cause of action should be dismissed.
That's right, Your Honor, that is. And then the second thing is it's not just a propensity to cause harm. It's what I think the key to this case is, and then there's a couple nuances. The key to this case is it's the propensity to cause, it's the same propensity that results in the injury.
Harm.
In the harm. So what we have here, just basically, and I know Your Honors will know the facts, but just real quick, we have a woman walking her dog. One dog comes out and smells around the dog. The other dog, take it for how the plaintiff says it, runs out. The dogs are then involved in what she terms to be a scuffle. There's a scuffling between the dogs. She either trips over one of the dogs knocks her over. So then when we look at the history of these dogs, we know from what we presented, my proof of my client is there was no aggression towards other animals previously.
But with respect to dogs, it's not necessarily just attacking in a vicious way. If there's a tendency, even in playfulness, being overly friendly that results in harm, your client could be liable.
I agree, Your Honor. So when we look at this case, where is that in this case? We have a dog. The argument by the plaintiff is...
Wasn't there a neighbor who said she was walking the dog and the dogs came charging out?
Correct, Your Honor. Assume that to be what that neighbor said. The neighbor said, I was walking my dog. The dogs came, let's call it charging out. The dogs stopped. The dogs never jumped on her. The dogs didn't bite her. She said she picked up her dog because she may have been concerned or afraid, but those dogs didn't scuffle around her. They didn't jump up on her. They didn't try to attack that other dog. And what we have here from the plaintiff is not, I think the case maybe gets characterized, I think it has to be recharacterized. I don't know if the way the plaintiff characterized it is exactly what the issue is. She's claiming these dogs charged out, that caused her to be afraid, that caused her to fall. She's saying what happened to the other neighbor walking the dog, Miss Dunbar, dogs came out, she was afraid, she picked up her dog, there was no incident, no injury. It's this idea that these are charging dogs, causing fear, fear causing some type of reaction, that causing injury, and that's the case law argued by the plaintiff. But that's not our case. Our case is dogs come out, the dogs either create a scuffle, or let's even assume...
Counsel, let me ask you a question.
Yes.
In this case kind of raises this issue for me. If somebody's getting out of their car in a parking lot and two big dogs come out of nowhere and charge, let's use that word, charge that person, and that person, seeing what is happening, reacts to that in a way that they panic and hurt themselves. They fall and hurt themselves. Would that fall into the category of a dog causing that injury, even though there's no contact between the dog and the person falling? Because the reaction is clearly a result of what the dog's doing in terms of charging. And it strikes me as that would be a natural human reaction on a couple of dogs charging a human being.
Correct, Your Honor, and I think you've hit the exact issue here. The question is, in that case, propensity to cause harm. So maybe that's a propensity to cause harm. We don't have that in this case. That's not this case.
So you're saying that this case is different, even though we may have some evidence of a prior incident where the dogs are off the property running towards somebody else, and they panic and pick up their dog, right? And so there's a charging there, let's use that word. You may disagree with it, and I'm not suggesting that that's what happened here, but just for purposes of trying to clarify the point. So if there is a prior charging, you're saying that that's not some propensity, even though in this case the dogs do a very similar thing. They leave the property and they run towards somebody who has a dog.
Correct, but Judge, in that case, in your case, that barking dog case, the woman becomes frightened, she falls down, let's say.
Mm-hmm.
This is not this case. You have these two dogs come out. Let's say these two dogs just walked out there to this
Even
woman.
with the evidence, the affidavit suggesting the dog's growling, that doesn't at least create a question of fact?
It doesn't, Your Honor, because first of all, on that, we've got to break this back down again. The dog's charging is a non-issue because that's not what caused the injury. That is not the proximate cause here. The proximate cause here... Your point
is that dogs here stopped.
The dogs here stopped.
And the charging allegation, to the extent that it even existed, and that's why you're willing for purpose of argument to concede it.
Correct.
Doesn't matter because the dogs here stopped.
Correct.
And then they began to do what dogs do.
They began to scuffle around, and Judge, if you were to say, okay, well, there was growling here, which the plaintiff says it may have been her own dog, she doesn't even know. Assume that. Where is the prior? There is no prior propensity of my dog to, let's call it attack another dog. That's why we're missing those elements in this
Or
case. That's why
even acting in an overly playful manner, there's no evidence
there's
of
no
that.
evidence of that.
I think we have your argument, Counsel.
Great, thank you, Your Honor.
Good afternoon, Your Honors. I'm Courtney Chemay on behalf of the plaintiffs, Diane and John Mecca, the cross appellants. I would submit to the court that the facts are very clear in this case, that plaintiffs are entitled to summary judgment. There was charging of approximately 120 pounds at the plaintiff. This had happened before. The manifestation of the plaintiff's reaction was she was injured.
But is there clear evidence that someone else was injured before due to the conduct of the defendant's dogs?
There is nothing in the record about a prior injury, but I would submit to the court that there are 2 instances of prior occurrences with the exact same activity of which the owners were aware of. Because Mrs. Dunbar's testimony, which is very clear, she spoke with the owner. The owner knew that the dogs charged off the property. And Mr. Minton, another neighbor, walked in the area and also witnessed these dogs coming off the property and ultimately retrieved by the owner. So I would submit
So
to the court.
would you be arguing that whether the dogs stopped charging, if they stopped charging and engaged in what dogs normally do before your client was injured, that where that action stopped is really for a jury to determine?
No, I think that Mrs. Dunbar was fortunate she and her dog were not injured. In this case, these dogs charged out, they did the exact same thing. Unfortunately, my client was injured. She was afraid. This was an attack. It wasn't a case, I don't know what the phrase dogs being dogs is. That's a phrase that was used in the briefs. The dogs were acting in a way that was harmful.
No,
The
you're
owners
here
knew
because
this.
you say that vicious propensities were established as a matter of law.
Yes.
But isn't the argument, getting back to what Justice Whalen was asking, isn't the argument that I heard from your opposition is that it's a proximate cause issue? Yeah, they may have run out there, that might be charging, but then normal canine behavior occurred with dogs playing.
I would submit that's flat out wrong. But for the fact that the dogs charged, she would not have fallen. If the dogs didn't charge out there, she felt that she was under attack. She called for help. She was afraid. Mrs. Dunbar was afraid. She said she felt threatened. This is 120 pounds of dog. You don't know what they're going to do. All of this happened very quickly, and she fell. It could have manifested itself in a different type of injury, or she could have been lucky and not been injured, but the acts of the dogs was the same in each of the prior incidents and in this instance. So I would submit to the court that the plaintiffs were in fact entitled to summary judgment.
Thank you, counsel.
Thank you.
Case 1278.1, Jones versus Shane Lawbecker and Joanne Lawbecker.
Good afternoon, may it please the court. Ryan Hutchison on behalf of the parents, Shane and Joanne Lawbecker in this appeal. I just have one comment I'd like to make to the court about the legal standard here, and then I know there's a lot of facts and circumstances we have to discuss. There's agreement between all the parties in the court that there's a standing issue here that we have to address in the process of the hearing, and then a best interest standard if we get to that point. I believe, Your Honor, that in the briefs from all parties, including the AFC, there's an agreement also that there's a strong presumption that the decisions made by fit parents about their children is in their best interest. And in this situation, Your Honors, there is no mention at all in this entire decision by Judge Church about that presumption, about how he addressed that presumption, and how he evaluated the evidence before him regarding to that presumption.
You represent the parents, am I right?
I do, that's correct.
Okay, so I think your point is even if we assume that they're standing, there's no proof that these parents are not fit.
That's correct.
And as you say, they're entitled to raise the children as they see fit.
That's correct. There was no meaningful argument and no evidence presented during the hearing, during the depositions, the documentary evidence that indicates that these parents are unfit. So this presumption would apply.
And when you go to the presumption, even taking into consideration the presumption and let's say for the sake of argument, the right of the grandmother, the equity side of it, they had a reason for making a determination that they did, arguably here. There
That's
were
correct.
circumstances that went from something arguably minor to quite significant, where law enforcement was called upon them, CPS was called in, and they decided they didn't want to be involved with that anymore.
That's correct, Justice Troutman, and I would point to the timing of the events that happened from June 25th to July 15th, that 20-day period. In a lot of the cases that are cited in my brief and in the respondent's brief as well, the court they look at those period of events, and they talk about what happened. In this case, I would concede that it was a trivial incident on June 25th. All the parties left upset. Then they look at, was there a cooling off period? Was there an effort to repair a relationship? Was there an effort on the part of the parties to actually de-escalate? Well, what happened here? And I know you know the record well. I'm not going to go into great detail with it. But the first night this happened, there's a call to CPS. We have that information. But there also was a reach out to my client, Joanne Lawbacker, the mother. And that outreach was by text message. And it's in the record. It's in evidence. What happened is that the grandmother reached out to her and said, essentially, Shane Lawbacker was out of control. He was angry. I hope you're okay. To which the mother responded, I think we see things differently. You should talk to your son. So we have this event where on Sunday night, CPS is called. Shane Lawbacker doesn't get a phone call. On Monday, Ms. Jones, the grandmother, admits she's in contact with CPS again, that she's speaking with them about this incident. On Tuesday, Mr. Shane Lawbacker finally gets some sort of communication from his grandmother, and she admits, without dispute, I sent him one text message that said, am I getting visitation this weekend, or do I have to take you to family court? Do I have to file that petition? And when he didn't respond on Wednesday, she lobbied
And he initially thought, because there's a history in this family of some tension between the brothers, correct?
That's correct.
So he thought it would cool over and they resume as normal family.
Judge, there's testimony from Mr. Lawbacker at the hearing that he indicates, but for the CPS incident on Monday when they found out about that investigation, that he did think that things probably would cool off.
When he left the house, he at least thought that.
That was his intent in leaving, Judge, was ultimately because he wanted to remove himself from that situation. But Judge, I just want to get back to that timeline. On Wednesday, 3 days after this incident, not only does she text the mother, but before she gets a response, she's filing in family court. She's filing her petition in family court.
So your position really is, it's really the grandmother's actions that really escalated this family dispute.
Absolutely, Your Honor, absolutely. And I wanted to point that out because, and again, I don't want to rehash all the information. I'd rather just take the questions. But all of these incidents that we just discussed, and then the July 15th investigation and interview with Officer Davis, which is a 3-hour video that I think Your Honors have, all of that information, Ms. Jones' involvement in the June 25th incident, her comments, the text messages on Tuesday and Wednesday, the family court petition, and then July 15th, going 20 days later to the police station to try to have her son arrested. Judge Church doesn't even mention those items or how they applied in his decision when he writes this decision. So the trial court passed right over that information. And I would submit that this court has the authority in this case, obviously to affirm, obviously to deny, but also to modify this decision if this court believes that the information that Judge Church did not address in his opinion, along with that presumption, would otherwise change the outcome of this case and should change the outcome of this case. The only other thing that I want to touch on very briefly, and I know it's been brought up a little bit already in a couple cases, is an issue of credibility. I know there's a deference to the trial court on credibility issues. There was a lot of information in this case about different points of views and perceptions, but this is a unique situation for this court. There was testimony in a deposition by Ms. Jones. There was testimony at a hearing by Ms. Jones. There was a supporting deposition given by Ms. Jones in this case.
There's a videotape of an investigative officer speaking to her at length.
And there's
not the brother who claimed to be the victim, but the grandmother petitioner.
That's correct. And during that 3-hour interview with the police officer, some of the information that she testified to, and I lay some of this out in my brief, wasn't just a difference in perception.
Right. So your argument is it's not a matter of discounting simply discounting the court's determinations as to credibility. It's the fact that the court did not consider all of the relevant evidence.
Absolutely. And there was no comment on her credibility, which I think is important in this case when you have multiple parties discussing these events. If there are no further questions, I have nothing further to add today.
Thank you, counsel.
Thank you.
Ladies and gentlemen, we need you to just wait here for a few minutes so the judges clear the hallway to get to their lunch. Then lunch is served if you're here for the CLA, if you're registered for lunch, that's downstairs. Some people have already started. There will be some speakers during the lunchtime, and the CLD will start at 1:45 back up here. Okay? So a little change in planning, but a little long here, but it was it.
Through here? Sure.
That's not Greg Peterson. I forgot, but it's his baby.
All right, so you guys don't need help with anything? You're good?
No, we're good, thank you.
Nothing. Want to do lunch?
No, that's okay, good.
All right.
Thank you, Dalton.
I would not.
I thought Mark was going to make that announcement. What happened to Mark? Yeah. All right. Yeah. You guys got the second half, right? Yeah. Yeah, you good.
Keep the box for the
Left it. I thought it went around in with that other stuff. Go ahead. Go ahead. Let me get out of here. We'll take our flag and put their flag back up. At least they'll have one flag. All right.
Yep.
I'm just trying to clean the bench down. You got a lot of thanks for the CLE, are you? You're taking the justices away now? No. At 1:45, they come back, at 1:30, they come back out there for a half an hour. At 2.
Is the CLE held downstairs or just the lunch?
Yeah.
It's all
The
downstairs.
CLE is up, for the judges are up here, am I correct?
I don't know, I assumed it was in here. I would assume, because.
Right, the lunch is downstairs now, and then after the lunch, the CLE should be up here.
You said they come back at 1:30.
Yeah, you know, 1:30, yeah.
I thought they were here at 1:45. You must have lied back. Greg, Peterson. No. All right, well, he was running the show today.
Okay.
He asked if I needed anything because the bench is going to be in the way, because I'm presenting the second part of the CLE, so I'm assuming it's in here. I thought it was here. Some of these CLE was going to start during lunch, so there is a table in the lectern down there too, so.
They should be down there getting lunch, because I think you said the clock said you said 1:45?
You better check in with some of those. That person clearly is not in this room. So to answer your question, we are here as long as the judges are there.
Yeah, okay. And that'll be one half an hour after they get off there, they're gonna be gone.
All right.
There's a cast and we're doing it downstairs. We are here. Okay. We're going to. Because we're gonna move the podium here. Okay. Hi, Greg Peterson. Winston, nice to meet you. So we'll be move this direction. And then, all right. Thank you, gentlemen. No. So with So what's going to happen, Chris, the court's going to come back here around 1:30.
Right, that's where.
1:30. Or whenever they get it.
1:45, 1:30, sure.
Yeah, whenever they show up, I'll do a quick introduction. They're going to do some presentations. And then they'll do a best practices, 25, 30 minutes, and then they're out of here. They're gone. Then I'll come up and introduce you, Chris, and you do and Winston, both of you, and you can do your thing. So it's from the podium. And then when you're done, I'm going to set up a couple chairs and a table over there, and we'll have Judge Martocci and I speak.
Front of the podium right here?
So the podium will be right here.
Okay.
So we're gonna move that here.
So everybody who is eating downstairs is coming out here for this one?
Yes.
By 1:30?
Yes.
Did you want Mark to take the seal, or John, will we taking the seal?
Let's do this, we'll move this. Is that our flag? No. And then, because I'm gonna have two chairs here, I'm gonna do an interview. Two chairs, and it'll be a small table here, so that's, just stage.
You want that out now?
Let's move this table just up against it. So. Kind of off center, look at this side.
What's in the ski bag?
Huh? The flag.
Oh, that's fine.
Our flag. Yeah. The state flag. and federal flag. We are going to second. No. Because I went to use it this morning. I didn't see it. You think it's down the other way? I know we picked it up to look at it last night, because you said it had to clear, right? What?
All right, we're reaching. You want to be closer, or do you think that's okay?
Wherever you, are you filming? Wherever you need it
Yeah, we're going to be filming.
Wherever works for you. Wherever you normally put it, I just put it back.
You don't mind if we film, do you?
No.
Okay, so I assume everybody wants to be. Yes, agreed. Even, of course. Right on top of that. Love it.
Where's our other stuff?
Oh, Judge Cass and Judge Foley are going to talk about electronic filings, surrogate court and county court. Large people, and they're not getting any ceiling cuts, they're just, they're filmed. So they were adjusting to everybody's schedule.
Let's check it out.
Justice.
Excuse me?
So what did you get about?
I don't need the other boxes yet. No, I don't need the other boxes yet.
No.
We carrying that stuff from. But other than that,
Does for the furniture maker, and that's what they do, they've done benches for federal courts. So I said,
So what do you do with this now?
well, it's a modular. It does move back, we'll ultimately do, next week, we'll move the whole thing back behind the curtain where the property stayed. So it comes back and forth. Pain in the ass to do, but it's.
Yeah. And you got room back there to store?
We have room, plenty of room back there to store. And what'll happen is we'll have mock trials, so all the city, county mock trials will be here. I don't think we'll bring this out unless, when you guys come back next year.
Something big.
Yeah, next year.
Did they build the tables for you too to match? Because it looks like it came with it.
Everything.
Okay.
This, cherry box, this.
Oh, this is new? You had a lectern or?
Yeah, lectern, nice lectern, it was downstairs.
Oh, that was downstairs.
You guys want a bite to eat?
Oh, I'm fine, thank you.
There is, okay. Yeah, so I'll just I'm gonna do a brief introduction to the judges. They don't need any other introduction, but then they're gonna do.
A view from the bench for half an hour, right? And then They all
I
want to leave.
assume, they're going to Syracuse.
That's right, Judge Centra's got his awards ceremony.
Right, so it's really up and up.
We do have really.
Yeah, I don't think it says what you said. Does it?
What?
I said, I don't think it says what you say, what the model rule says.
Yeah, absolutely. 8.2.
What does it say?
It says it's every, no attorney shall make any false or reckless statement about the qualifications, integrity, record of the judge. Because 8.2b says all candidates for judicial office must also follow that.
Invoked that before.
It's free. It's only been
Has it been
cited.
held unconstitutional?
No, that's what I'm talking about. It's facially overbroad.
Yeah.
And so there's a ton of out-of-state cases narrowing it, and that's what I'm going to talk about. It's only ever been cited one time, as far as I can tell, by a New York appellate court in matter of Hudson, the third department case. And there, it was only in the context because it preceded it was still under the code of professional responsibility.
Yeah.
So they only cited it in the sense of they cited some parallel provision, and I couldn't correlate what the prior provision was, and all they did was they quoted the prior disciplinary rule, and then they just said C, Model Code of Professional Conduct, or Code of New York Code of Professional Conduct, Rule 8.2a, meaning implying that that was like the modern corollary. And it was very clearly a criticism of the judge case, because it was a case where the lawyer accused a bankruptcy judge of altering a filing.
Now, is it in the current version of the rules of professional conduct? 8.2?
Yes. And I checked it on Westlaw. It's in the, it's in the N.Y.S.
Well, yeah, because I did a bunch of research on when we did that.
That's the last part. Yeah.
A couple other ones.
It wasn't charged.
It was, I was wondering,
It was-
everyone relies on 8.4 in
Right.
New York.
That's sort of how
Which to me makes me wonder whether that one's like constitutionally dicey and they don't
It
want
is.
to get into
It's dicey.
It's just easier to go to 8.4D. Oh, you've, prejudiced the administration of justice, which is clearly a
It's
constitutional.
totally under Gentile against State Bar of Nevada,
Right.
the Supreme Court.
That's what I was going to say.
And so, yeah, it's never been really.
You might have more than 20 minutes.
No,
Maybe I should
no,
just
no,
step
no,
aside.
no, no, but
You
there-
can take the
there's-
whole history. No, 'cause that's a pretty complicated issue.
But there's just a ton of cases from the federal circuit courts.
Yeah.
And I'm going to talk some about a Delaware Supreme Court case that I think